Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Desmond. To my left, Justice Allen. We will be hearing 6 cases this morning. The rules are, as they always are, which is 15 minutes per side and no rebuttal. We will take our traditional mid-morning break after the first 3 cases. We have read your briefs with some care and know the facts quite well, and so you may want to get right into your arguments, but it is your time to do with as you wish. The first matter we will hear today is number 25-1077. This is Commonwealth versus Gonzalez, and we will hear first from Attorney Weber.
Good morning. Philip Weber representing Mr. LEONEL Gonzalez. Mr. Gonzalez's case is here today because he did not receive effective assistance of counsel. While there are multiple issues, I will focus on what I believe to be the most significant of them, being that essentially trial counsel, well, just not showing up to court. The date of the initial trial schedule, because as your honors are aware, it was continued, and indeed it was continued because, in large part, the trial counsel didn't show up to court. Now, clearly, there's no tactical reason to not show up to court. I think
the first trial was continued because defense counsel wasn't there?
Well, there was some previous continuances that was not the issue, but ultimately...
Hold on, I just want to be clear. I thought I heard you say the first trial was continued because defense counsel wasn't there. Is that what I hear you say?
Maybe I should phrase it a little differently to make clear. My apologies in that regard. Because originally it was going to go to trial March 23rd of 2023. At that time, the Commonwealth wanted to continue the case because of an unavailability of a necessary witness, a police officer. That one was allowed, so that's not the issue in that regard.
It got a new trial. Before that, Commonwealth moved again because the witness still wasn't going to be available. They said, well, mark it up for a hearing on the scheduled trial date, and that's when counsel sent substitute counsel, right?
Correct, Your Honor. So, because previously there had been an agreement to continue. This one that was marked up was not an agreement, and that was the one where trial counsel simply didn't show up.
He sent substitute counsel. Is that fair to say?
There was somebody there, an attorney, a different attorney. The problem with that different attorney is that attorney filed a notice of appearance that day.
I understand.
So there's no way that attorney could have actually gone forward. He was essentially a warm body there so that they could say, well, he has someone here.
Let me ask you this question, if I may. With respect to Attorney Malcolm, where was he on that day when he sent substitute counsel?
Apparently in another court dealing with a different case.
I read that he was held in that court. Is that right?
They might have, if I recall correctly, I believe so, Your Honor. But
okay, so being held in another court, he sent a substitute counsel for his matter that was on for hearing on a continuance.
Well, technically it was on for the trial date, but the Commonwealth had filed a motion to continue because it was set for to be a trial date.
I get that. And the judge said, we'll hear the motion for continuance on the scheduled trial date.
Correct, Your Honor.
So it became a date for a motion for continuance.
In essence, well, to be heard on that date, so because essentially it was the point where either the motion to continue would be granted or the other option being that it would have to go to trial, but since the Commonwealth wouldn't be ready without that essential witness, they would have to answer not ready, and then the case would have been dismissed. So
Possibly. It would have possibly been dismissed.
Well, it was the point where the judge on the date of did state, I was inclined to deny it and potentially dismiss these charges, and in fact even said, were Mr. Malcolm here, I would strongly consider dismissing the matter. So
right, but he didn't say I would dismiss it.
He's not 100%, Your Honor. So yes, it is true that there's not 100% certainty, but in regards to the standards, Your Honors are aware, there doesn't need to be 100% certainty that a case would be dismissed in order for it to satisfy ineffective assistance of counsel standards.
Let me ask you this question. If Attorney Malcolm was held, what was he supposed to do?
he was supposed to plan his schedule better and deal with the fact that he knew he had this date and he knew he had other, I mean, part of being a practitioner, I know I experience it myself, is you need to plan your schedule accordingly. You need to make sure that you don't have these overlapping dates so that you don't have the possibility of being held. I'd say that is very much a duty that an attorney owes to their client, to schedule things appropriately so that the situation doesn't come up. It's not as though this trial date just came out of nowhere, not as though this date, none of these dates simply came out of nowhere.
Saying the standard then is that it has to be, primary counsel has to be there. He did send in somebody else who had an appearance. What about an associate, if it had been an associate? Is that ineffective assistance if a partner sends an associate in?
Well, I would say it would depend. If the associate was prepared and ready to go forward with trial, then it would not be an effective assistance, because that's essentially what we're dealing with. It's either the continuance is granted. If it's not, then you have to have someone who's actually ready to go forward. And the trial court correctly stated they couldn't go forward with Attorney Russell, the attorney who had been there that day, because he filed the notice of appearance that day. He had never actually met with the defendant. There's no way he could actually have gone forward with trial. If someone had shown up who could have,
That attorney answered ready, right?
he stated that he was ready, but
He answered ready.
and I would argue that he was not ready,
I understand the argument.
to the point where even the trial court noted he was not ready. The trial, in fact, the judge in the trial court stated that he couldn't possibly go forward. If they went forward with the trial, that would have been an effective assistance to have Attorney Russell go forward. So essentially, that's by not showing up, because it stated if he sent someone who knew the case well enough, ready to go forward, that's one thing. But this person couldn't go forward. All they could do was stand there and say, well, the Commonwealth doesn't have their witness.
I hear you say that, and I understand that, but at the end of the day, the counsel answered ready.
Counsel said that word. Counsel answered ready. I would argue that he was not.
Did the judge find that he wasn't ready? The judge says, there's no way that I'm going to force a trial on a lawyer who candidly admits he just met his client today. Can someone be ready if they just met their client today?
I would argue no, Your Honor. I mean, and it's not just that he just met the client that day.
Well, they'd never spoken, he'd never heard of him, and so forth. It's a complete stranger who walks in.
Correct, Your Honor. And it's not just that he was a stranger, it's also that there was no indication. If somehow there was some indication that maybe he hadn't met the defendant, but he had been, reviewing the case files vigorously, had gone forward, that would, still I would say be questionable, but that would at least be something. But there was no indication even of that. There was no indication that he, knew the facts of the case forward and backwards, had questions ready to ask all the people. So I think it is significant that he had never once spoken to the defendant, and there's no indication that he knew the case well enough to try it.
Can we talk about the broader argument that you make about just the utter failure of the lawyer, failure to discuss the case with him, except in these 3 5-minute phone calls, never going to see him when he was held, never met him in person after the arraignment. Does that add up to ineffective assistance of counsel?
I would argue, given the totality of the circumstances, yes, that it does. That alone is, I think, quite significant. A defendant is owed from their attorney this ability to consult about the case, to discuss the case. Certainly I know as the attorney who does trial work myself, I know that the attorney is one who's kind of maybe driving the ship, but it is the defendant who lives with the consequences one way or another. They need to be able to have input on the case, to be able to discuss it with their attorney, to at least know what the strategy is going to be prepared, to be ready, to have someone who a few 5-minute phone calls that's basically nothing. At that point, there's no real level of communication. There's no real way for the defendant to know if his attorney has any real knowledge of the facts, in addition to the fact that a lot of times significant information is gleaned from speaking to the actual defendant. Because certainly there's police reports, there's other discovery, but when all is said and done, you have the person who lived through whatever they lived through talking directly to you. But they weren't this time. Attorney Malcolm didn't get any of that information that could have potentially been significant and information that matters because it it weighs on so many different issues. Is he going to testify in his own defense or not? There needs to be a significant conversation in regards to that. How are they going to proceed on trial? How are they going to go forward with things? I mean, there are things that have to be discussed, and a couple of 5-minute phone calls is just, it's not going to be able to have that level of discussion. It's not going to be able to go through the case.
How long did Attorney Malcolm represent, at the time of trial, how long had he represented the defendant?
He had been on since the beginning. I mean,
How long is that?
I remember that I put it in my motion, and I apologize I don't have the exact date, but when he was first charged in district court.
It's almost 4 years, isn't it? Wasn't he
I believe
arraigned
so.
well, his notice of appearance is July 2020. I guess maybe the arraignment is in October, and then my notes at least say between October 2020 and January 2024, all he'd had was these 3 phone calls.
Correct, Your Honor.
And this is a privately retained attorney?
Yes, Your Honor.
Okay, so he didn't fire him?
No, he didn't.
Did he ever bring it to the attention of the court that, Judge, my guy's not showing up, he's not calling me, he's not representing me adequately? Did he make any complaints to the court in 4 years?
No, Your Honor, he did not. He probably should have.
Wait. Was he a lawyer?
Well, that's what I was going to say next. Is that,
How's he supposed to know what he has to do?
Your Honor, it's like you predicted the next words out of my mouth. That's to say that maybe he should have, but he doesn't know the system well enough to know what he should be saying. He incorrectly, obviously, thought, well, this is what's supposed to happen. This is, the guy I hired, paid him.
I don't know what he thought, but I'm just asking whether we know that he knew how to do any of these things. I mean, I don't know what he thinks the role of a lawyer is or the relationship of lawyers to the court itself. I have no idea.
He put trust he incorrectly put trust in the wrong person. So Your Honor's correct. He didn't know the system well enough, and he did what a person normally would do in that situation. Well, I hired this person. They seem like they're an expert. I should rely on them, and certainly he was incorrect, but no one in this situation would be able to truly know that their attorney was ineffective. I don't think that's ever been stated in any case that the defendant has to be aware of it. It's unfortunate, certainly, but that was the problem. He didn't realize he thought he had an attorney. In fact, at one point he does make a statement. I don't recall the exact wording, but I did put in my brief in regards to, I'm relying on Attorney Malcolm. I'm kind of like, he said everything would be okay, so I'm relying on him. That's what he did. He relied on the person who represented themselves to be a competent, effective attorney, despite the fact that they were not. Because really, showing up to court, and not to keep going back to it, but I do think it's perhaps the most egregious one, because if he shows up to court, and if the case is dismissed, we really do get into, I would say, the significant speedy trial issue, because obviously, if the Commonwealth were able to bring it back to trial date, then that changes things, but I think it is.
That hasn't been calculated, right? All we have is the assertion of the Commonwealth on the one side about what some number of these days, which are excludable and which are not, and you don't have an exact calculation either. Is that right?
No, Your Honor. I do not have an exact calculation, but even going with the Commonwealth, they put in their brief 334 days. Now, I'm not saying that I agree to the 334, but they're conceding to 334 days as of the date that we had this motion to continue hearing. So already, we're really bucking up right on the edge of it. And in fact, one of the significant things, while I didn't do maybe the full calculation, even within that 334 days, the Commonwealth's counting from the moment he was indicted in Superior Court, as opposed to District Court. And citing to Commonwealth v. Butler.
They concede that, right? They concede that in their brief.
I don't believe they conceded the Butler one, the 300.
That they accidentally did not calculate the time from the time when he was arraigned in District Court to the time when he was arraigned in the Superior Court. And then in that brief, I believe they did the math over again.
Well, I certainly would have to check the record again to see if I'm misremembering, because they did make a correction, because at first in their opposition in the trial court, the opposition to the motion for new trial, they put 310. And then in their opposition brief, they put 334, which I believe I recall was for a different reason, for something else they overlooked. And even if we look at 334, because that was.
Let me interrupt you for 1 second.
No, of course.
What was the defendant charged with?
The charges are in regards to possession with intent to distribute in regards to.
What were his exact charges, if you know?
I do apologize, Your Honor, that I've been so focused on the different parts of the speedy trial issues that I was not focusing quite significantly.
Well, you're a capable attorney who's prepared, right, for this case, and you've met with the defendant, right?
Yes, Your Honor, many
Okay,
times.
so what's his charges?
From what I remember, Your Honor, I remember the possession with intent to distribute.
So he was charged with trafficking and possession with intent, second and subsequent offense, right?
Yes, Your Honor.
Okay, so that means he's been in court before?
Yes, Your Honor. It's not his first
How
time
long
ever.
is his record, if you know?
I did not review the full record as I didn't find it to be relevant for the issues in his brief for the appeal of this today. But even so, he'd been in because even if we went with the 334, even if that was measured from district court, that still leaves us to the point where there's 32 days left. They would have to re-indict and bring it to trial within 32 days. Now, they've claimed that, oh, they could have re-indicted incredibly quickly, but we're also talking about a situation where they had a necessary witness, a police officer, so not a random civilian that you have less control over, 2 times be unavailable for significant court dates. So this assertion that, oh, we could have re-indicted the same day, I think is...
Do we know if it's the same officer?
I believe so, Your Honor. I believe from my recollection of the record that it was the same one. And even if it was different ones, that would still show. I mean, I understand that there might be necessary witnesses and juggling that is something, but that is the role of the Commonwealth. That is one of the things they're supposed to do, to have their witnesses available. So to re-indict, they would need to have the necessary witnesses available to re-indict. And even if they can re-indict, it would be who knows how long. The idea of the same day, I think, is quite a stretch. And if they do it, even if they do it quickly, they have to re-indict and get it scheduled for trial, because certainly at that point, it's not as though the defendant is going to concede to any types of continuance within 32 days. And that's assuming that the calculation they give is exact, which, again, I'm certainly not conceding to that. Seeing my time, unless
Your
there's
time
further
has
questions.
expired, although if there are further questions, I see none. Thank you so much. We will hear next from Attorney Jansen.
Good morning, may it please the court. Catherine Jansen on behalf of the Commonwealth. I guess I'll start first with Attorney Malcolm's failure to show up at the November 6th, what was originally a trial date, but was really set on for a hearing date for the Commonwealth to advance and continue. I would suggest that it's speculation that the judge would have dismissed this case. I think it's clear he was frustrated, and he used language that I would initially considering or possibly would dismiss the case, but he also, in the same sentence, said, I need to hear from the Commonwealth about what they have to say. And once he learned that it was going to be a short continuance, he said, well, that's reasonable. So I think to say that he would definitively dismiss the case and that he was deprived of the defensive dismissal is speculative.
He only has to have a substantial ground of defense lost, right? We don't have to be sure that he definitely would have won the motion, but if it's a substantial ground of defense that's lost through the ineffectiveness of counsel, that's enough. Don't you think it's at least a substantial motion?
I don't, because I don't think it is a credible assertion that the judge likely, to say that, you can say anything could have happened. I think that's essentially what the defendant's saying. I don't think saying anything could have happened, that this possibly could have happened, is enough to be substantial.
The judge said he was thinking of doing it. It's not just, I mean, I understand we don't know what the judge would have done. In that sense, of course, it is speculation. But the judge certainly made it sound like a substantial motion.
I would just suggest it's not a substantial motion because, again, it's linking it down to anything possibly could have happened. And especially knowing, I guess this is not part of the record, but judges get frustrated, I think, when things are continued, especially at the age of the case, and sometimes they just say things off the cuff because they're frustrated, and then they sit down and look at the motion, and they look at the merits of the case. And so, again, I don't think that rises to the level of substantial. I'm happy to address the other issues of ineffective that my brother raises if the court has questions on them. Otherwise, I am happy to rest on my brief.
I don't see any questions. Thank you very much.
Thank you.
The next matter we will hear is number 25687, This is Commonwealth versus Burgos, and we will hear first from Attorney Jacobson.
Good morning. May it please the court. Haley Jacobson on behalf of Giovanni Burgos. According to the state police policy, an inventory is a non-investigative procedure in which the contents of a vehicle are itemized and the condition of the vehicle is noted. Here, there is zero evidence that the troopers itemized the contents of the vehicle or noted its condition. The testimony that the Commonwealth points to as evidence of an inventory search is testimony about the troopers searching a bag on the front passenger seat, which contained the contraband, and conclusory assertions that by the troopers that they did an inventory. As to searching the bag on the passenger seat, that shows that there was a search, but it doesn't show that there was an inventory search. And as to the conclusory assertions by the troopers, those cannot be enough to prove that the inventory was done for a legitimate purpose and in accordance with the standard written procedures.
Pursuant to the Massachusetts State Police standard policy on inventory search, did they comply with that?
Well, there's no evidence that they did, because the policy requires the...
Did they itemize any valuable things that may have been discovered in the car?
No, as far as we know, they did not. They did not make any list of items in the car, didn't search the entire car, didn't write down what they found inside. So no, I mean, in any ordinary sense of the word inventory, that wasn't done here, or at least there was no evidence that it was done here.
And does the state police policy require them to make a record of the inventory of the vehicle?
Yes, it does, Your Honor. The state police policy requires them to itemize what's found in the car. I think inherent in the word itemize is writing it down. Otherwise, there's not really any purpose in making the list if it can't be referenced later to make sure to safeguard the contents of the vehicle, the defendant's possessions, and to ensure or to protect against false claims. That really can't be done if there's nothing written down.
And how do we know that they only searched the duffel bag and searched no further?
Because the troopers never testified that they searched anything else. All they testified is that they searched this one bag. And so there's nothing else to be gleaned from the record that there was any other kind of searching here. And without that evidence, the motion judge couldn't possibly have evaluated whether this was a genuine inventory search for the permissible inventory purposes and whether the search complied with the policy.
The judge's findings were, I credit the police officer's motion denied.
That's correct.
Could you credit the police officers and still allow the motion? I don't understand finding the officers credible, how that speaks to whether or not it was an inventory search pursuant to the state police policy.
Well, I agree that the finding the officers credible doesn't answer the question, the legal question here, which is whether this was a genuine inventory search. And I think we can take everything the officers said as true, and still that leaves the question, the legal question for the court, which was, did the Commonwealth prove that this was an inventory search done for inventory purposes? And so the judge's findings, to the extent there were findings, didn't answer that question, but this court, would review that legal question de novo, so is perfectly able to do that now even.
So should we, if we agree with that, should we reverse it or should we remand it?
I don't think a remand here is necessary because there are no additional findings of fact that are necessary to decide.
We want to know why the judge for further findings from the judge as to why she credited and denied it. I mean, she didn't actually, as far as I can tell, analyze the arguments to any great extent that were made in behalf of the defendant.
I agree that she didn't do a legal analysis, but I think the factual findings, which are what is most important for the motion judge to make, are enough here. She found the officers credible, so we can accept everything that they said as true, and then the legal findings, we can assume she rejected, all of the defendant's all of Mr. Burgos' legal arguments, but then this court would review those legal questions de novo, so there's not any need for it to send it back. In terms of judicial economy, it would sort of take unnecessary time for the judge to make additional legal findings that this court would then review de novo. So I think this court is in as good of a position to review the legal questions as it would have been if the motion judge had made more extensive legal findings here. And one thing I just want to be clear about is that the fact that the Commonwealth failed to prove that this was, in fact, a genuine inventory search alone requires suppression, regardless of whether the impoundment was reasonable or not. In other words, it's not enough that the inventory search was objectively justified. It had to be subjectively a true inventory search. And like as this court said in Ortiz, even if otherwise valid, an inventory search must be conducted for some legitimate police purpose other than a search for evidence.
Could it have been a search incident to arrest? Weren't they going to arrest him anyhow because he gave a false name or had no ID?
They did arrest him, but A, the Commonwealth has not justified the search as one incident to arrest, but it also could not be because Mr. Burgos was far away from the car at that point, and there was no reason to think that evidence of the crime of not driving without a license would be in the car, and certainly there was no evidence to support that here. So it would not be justified as a search incident to arrest, given that Mr. Burgos was nowhere near the car at the time of the search. So, in other words, in terms of the inventory search, the Commonwealth had to show not just that they could do an inventory search, but that they did, in fact, do one. And here there is no evidence to support that, and the Commonwealth simply did not meet its burden on that question. Now, turning to whether the impoundment was reasonably necessary, the crux of the issue here is that the troopers failed to tell Mr. Burgos that the car was going to be towed, even though the policy implicitly required them to do so. And because of that, he was deprived of a chance to request a lawful practical alternative, which under Oliveira, the police would have had to honor. Now, it's true that the SJC has never said that the police officers are required to tell a driver that their car is being towed, but the court simply, or the SJC simply has not addressed that question, and this court could and should, because it makes sense that if the driver has a right to request a lawful practical alternative, that right doesn't mean very much if he doesn't even know that his car is going to be towed. And here it's notable that the state police policy, in fact, did require the troopers to ask Mr. Burgos if he preferred a particular towing company, which would have informed him about the towing and given him an opportunity to request a lawful practical alternative.
And is he entitled to that no matter what the criminal circumstances are that we put them in that situation? So if they saw guns on the front seat of the car, or if he had just shot somebody, is he still entitled to be asked, hey, where would you like us to tow your car?
Certainly, I think there could be emergency situations where the police would not be able to ask the driver what his preference would be. For example, if the driver's, is unconscious or not able to respond, or the police need to act quickly, that might be one thing.
What if it was an OUI?
If it was an OUI where the defendant is conscious and able to make decisions, I don't see why that would change the analysis. But as to Your Honor's point about there being guns on the visible in the car, well, the police wouldn't need to justify this as an inventory search in that case, because that would itself provide grounds to search the car on probable cause. So I think as a general matter, and certainly in this case, where there was no reason the police couldn't have asked Mr. Burgos what tow company he preferred, and then he could have offered that alternative, there's no reason the police couldn't have done that here, and they should have under Article 14 and under their own policy.
It seems odd to me that they would be required to do that. Here's a defendant who is being somewhat evasive. He's given them a false name and information, and they were able to figure that out, and yet he's still entitled to these protective rights.
Well, certainly the defendant is entitled to his Article 14 rights despite giving a false name, and the police did, even before he was transported to the barracks, they did ascertain his true name, and at that point, they had no reason to be concerned, the trooper testified, about him driving the car, and so there's no reason that they couldn't have and shouldn't have given him that opportunity here. But in any event, as I said, the fact that the Commonwealth failed to prove this was a true inventory search alone requires suppression. So the court doesn't necessarily need to reach the question of whether it was reasonable not to inform him about the towing, but the court certainly could. But it's not necessary here because there's this other grounds for suppression and another grounds for which the motion should have been granted. And unless the court has any other questions, I would ask the court to reverse the order denying the motion to suppress.
I see none. Thank you very much. We will hear next from Attorney Simonian.
Good morning, Your Honors. May it please the Court, Elizabeth Simonian for the Commonwealth. Today, the Commonwealth respectfully requests that this Court affirm the motion judge's denial of the defendant's motion to suppress. This is a case that presents the straightforward application of well-settled Fourth Amendment inventory search principles. And when we look to the two-part test the Court set forth in Oliveira, first we look at whether the impoundment was reasonably necessary. Here, that is the case. And then we also look to see whether...
Is it your position that the state police complied strictly with their policy that you entered into evidence?
There was a concession made by the trooper at the motion to suppress hearing that there was a failure to document the inventory search. So as to that point, the trooper was honest that there was a mistake made. There was a trainee on scene. He was helping fill out those documents.
And I've read your brief. There are cases that say that that's not going to necessarily require suppression, right?
Correct, yes. There is a specific case on that point. That would be Torres 85 Mass App Court at 53 through 55. That is almost exactly similar to, or almost exactly like this case here, because the only problem there was the post-search documentation error.
Do we know if the state police actually searched the entire car?
Based on the evidence, we are looking to decide whether, so the standard at the motion to suppress hearing would be more probable than not. So was it more probable than not that the motion judge could have concluded based on
No. My question's differently. My question is, did the state police testify that they searched the entire car?
There was no specific testimony that the state police did search the entire motor vehicle. However, we are aware that there was a search conducted. And here, these are
Wait.
not
I'm sorry. Slow down a sec. Of course there was a search conducted.
Of course.
The question is, has the Commonwealth justified the search? A search was conducted, but that doesn't get us almost anywhere here. But they're saying it's an illegal search, and you're saying it's a legal search. To be an inventory search, you have to search everything in the car. And you're saying that you didn't put in any evidence of searching everything in the car, right?
There is no case law that states that the police have to testify specifically to searching every nook and cranny of the vehicle.
Okay, how much did they testify to searching?
They testified to searching. There was one trooper who started on the driver's side of the vehicle. There was one trooper who started on the passenger side of the vehicle. As soon as they get into the vehicle, there is a nylon bag found. However, I would like to point out that the inventory policy itself states that the bag, any unlocked containers, must be opened and inventoried separately.
No question they can search the bag. No question they can search
Yes,
the bag.
so even though, as my sister had alluded to in her brief, that the troopers immediately went in there with a hunch because they looked at this bag, they grabbed this bag, they searched this bag, they were required to search that bag whether they did it first or whether they did it last.
Both of those things can be true. That just speaks to the real intent, which is questioned. Is it an investigative search or is it an inventory search? So the fact that they went right to the bag may point somebody to say that it's an investigative search. So we're looking for the evidence that it was broader than that it was an inventory search. So what else did they search?
Well, here we have several points of testimony that are important to hear, not just that, as I had stated before, the officers did not testify to searching every aspect of the vehicle. But again, at a motion to suppress hearing...
Did they testify to searching any aspect of the vehicle aside from seizing that bag?
Well, it's more probable than not that where one person starts...
The answer no to that question?
The answer is no, they did not testify to searching every aspect of
Did
the
they
vehicle.
testify to searching anything aside from the bag?
They were in the passenger side. They reached into the passenger side.
Yes, I understand that.
It is more probable than not, based on that standard, that there was sufficient evidence before the motion judge for her to conclude.
I'm sorry, I don't understand that. If I say I opened the passenger side door and I saw a bag lying there in plain view and I took it, and under the policy, I opened it, and I looked at it. How does that make it more probable than not that you also searched the back seat area?
Because this case, there is no discretion of the officers here because the towing and the inventory policies require that that vehicle be removed in inventory. This case is not like Ortiz.
Wait. But you agree that the fact of whether they inventoried it, not the fact that there's a policy, that the Commonwealth has to show that it adhered to the policy. Do you agree with that or no?
I agree, but the policy doesn't require an officer to go into court and testify to searching every
The policy
aspect of the
doesn't
vehicle.
require any
It's a requirement.
testimony, but there is a requirement that the Commonwealth demonstrate that it was pursuant to the written procedures.
Well, then we can distinguish this case from several other cases because this was not a pretext case. We look at Ortiz, as my sister had pointed to. That is a case where the officers were working off an undisclosed tip that the defendant was drug trafficking. They knew that he had a suspended license, and so they waited for him to get into a vehicle and to drive down the road where they knew they were going to catch him and use that the operating after suspension charge in order. Then they were going to use the inventory procedure to get into the vehicle. That is what they did. Here, we have reasonable suspicion that justified the stop because the defendant is speeding. They properly extended the scope of the stop with certain questions about weapons or drugs. And then we have probable cause to arrest because this defendant committed not just a criminal offense, but an arrestable offense under GLC 90, Section 25.
I don't think anybody disputes any of that so far.
Yes, so then we get into, there is no choice here but to inventory, to tow, impound the vehicle because the defendant is the sole occupant. There's no owner on the scene. He's not authorized to drive in Massachusetts. He has
Focus
four
right now
default
is on
warrants.
the inventory, not on the tow. The focus is on the inventory right now.
Okay,
You entered a written policy that protocol that the state police have to follow.
yes.
And so the question is, and I haven't heard a clear answer yet, I'll be honest with you, is did they search anything other than, explicitly search anything other than the duffel bag? And if so, tell me where and where that is in the record.
I can't tell you that because there is only testimony as to searching the bag.
Okay, so do you think that that complies with the standard, the written policy that they entered?
There is, but we're looking at whether the motion.
Is that a yes or a no?
The written policy doesn't state that it's more probable than not that these officers search the entire car.
What does the policy say that they're required to do? Let's start there.
The policy here tells us, one moment, please. They are required to document, yes, and that was an honest mistake that was made. But here they're allowed to open any unlocked and open containers. That fits squarely, searching the bag.
What else are they required to do? What else are they required to do? Just tell me what else.
One moment, please. The following areas shall be inventoried. The interior of the vehicle, the glove compartment in the trunk.
Did they look in the glove compartment?
It does, the testimony doesn't say that, so I
Easy.
can't, respectfully, I cannot tell you that because the testimony doesn't state that. So I can't give you an affirmative or a negative because I don't have the answer to that. All I have is what the motion judge relied on, and because the motion judge credited the trooper's testimony here,
Did the troopers testify that they searched the glove box?
no, they did not.
Okay.
They
So even
testified,
if she credited their testimony, they never testified that they searched the glove box?
no, they testified to their knowledge of the tow and inventory policies and why they applied in this case. They testified to their presence at the scene when an inventory search occurred. They testified to the details surrounding their participation in the inventory search, specifically
So
their
that's what we're trying to
location.
get at, the details of their
Yes.
participation.
They testified to the contraband discovered during the inventory search. And like I said before, Trooper Zeminski was honest about the lack of inventory search documentation. He looked into that. He didn't know what happened, but an inventory was still taken. That is credibility at its finest. He didn't evade the question. He didn't lie about the question. He said, yes, there was a mistake made. And as I stated before, Torres tells us that a post-search documentation does not affect the validity of the inventory search here. And my sister relies on to Sheriff Furtado for the proposition that the trooper's testimony that they conducted the motor vehicle inventory was conclusory or insufficient to prove the occurrence of that inventory. But that was the only statement that was made, which was central to prove the legality of the stop, was the trooper stated the vehicle was traveling at a greater speed than reasonable. That was the only statement to prove that fact, and the Commonwealth failed to offer evidence that the officer estimated the motor vehicle speed, compared the speed to anyone else or himself, clocked the defendant on a radar. Here, I just told you that there is more than that in this case, and we have to, the motion judge's credibility determinations are entitled to deference from this court. And so by her explicit credit to the officers, then when we believe her, it is reasonable that the officers did an inventory search. I would argue that the impoundment of the defendant's vehicle was reasonably necessary for some of the reasons I've already stated. And although there was a mistake made in the post-search documentation, the inventory search is not invalid on that basis either. The towing policy authorized removal simply because the operator was arrested. The motor vehicle would have been left unattended. And a second reason is he wasn't properly licensed and there were no properly licensed occupants. The inventory policy mandated that when the motor vehicle be towed, removed, or impounded as outlined in the inventory policy or pursuant to a lawful arrest when the motor vehicle would be left unattended. So for those reasons, there was no discretion left with the officers to decide much here. The policies required that the vehicles be removed off the roadway and searched. And if there are no further questions, I would respectfully request that the court's order be affirmed.
I see none. Thank you very much.
Thank you.
The next matter we will hear is number 241456. This is Commonwealth versus Candello. And we will hear first, when everyone's ready, we will hear first from Attorney Murphy.
Good morning, Your Honors. Owen Murphy for Antonio Candello. So under Counterman, the Supreme Court decision, reckless intent provision within the witness intimidation statute.
Can you move the mic a little closer to yourself? Okay.
Is that better?
I don't know. We'll find out.
I'll try and keep it up. The reckless intent provision in the witness intimidation statute is unconstitutional. In this case, the jury was specifically directed that a finding of specific intent was completely unnecessary to their verdict. And in these circumstances, based on this record, I'd submit that there's a reckless...
All right, so let's back up for a second, because I want to get all the steps till we get to this. I want to understand your argument, because I found it a little confusing. You don't say that with specific intent it's not okay. You're saying if they were instructed on specific intent, they can convict under this, leaving aside overbreadth. You know, the first part of your argument about what's unconstitutional about the statute as applied to your client is this speech can be criminalized, or, yeah, I guess it's all speech. Some of it might not be speech, but whatever speech comes into intimidation, harassment, and those things. As long as there's specific intent, that can be prohibited. That's your position.
That's what Counterman says, correct? And that's our position.
Well, I don't know if Counterman spells out everything about all these different intimidation, harassment, but all right. And then you say, but reckless disregard that it may intimidate a witness or interfere with a proceeding, that isn't enough, because this is more like incitement than like threats. And you say the reason is, if I'm, please correct me if I'm wrong.
So far, yeah,
you say the reason is this edges on, which is a imprecise phrase used by the court in Counterman. This edges on protected speech in a way threats don't,
Correct.
but in a way incitement does.
Correct.
Tell me how it edges on protected speech, and give me whatever examples you have of the protected speech that it edges on.
Yes, so I think probably the best example would be if you look at the case of Commonwealth versus Cruz, which is the 2004 case. There's two of them I cited within my brief. One of them interprets Counterman, but the 2004 Cruz case specifically talks about an instance where the defendant actually alleged that the Commonwealth violated the witness intimidation statute by granting an immunity agreement for a testifying witness. And the court states that no, because they were attempting to procure truthful testimony, that's not interference. Interference means something more malicious. And so in that case, even though they're interfering with the testimony in some sense, it's not interference under the witness intimidation statute. So that's something that's right across the other line, because what if the defendant is specifically intending, sincerely advocating for the truth? Why can't he approach a witness in the same way that the Commonwealth does with an immunity agreement?
Okay, so I'm going to have to look at that 2004 Cruz case.
Yeah, it's
The difficulty I'm having with this edges on idea is that this doesn't cover all speech encouraging someone to tell the truth. It only covers someone who threatens, attempts or causes physical, emotional, or economic injury or property damage. I know you have arguments about the vagueness of some of that, but still, it's not just any encouragement. It has to, under the text of the statute, attempts or causes one of these things. To convey a gift, offer, or promise of anything of value, maybe that's what Cruz was about, because of course you do get something of value in that case. Misleads, intimidates, or harasses. And I don't see how the motive, but it's to tell the truth, makes any difference for all of those.
Yeah, I think in some contexts, I agree with you that it doesn't, because there's not a substantial amount of protected speech where somebody's threatening to cause physical harm or violence. But in other instances, it would.
Other instances that aren't covered by the statute.
I call them the conduct clauses within my brief, correct? I mean, you could threaten somebody with litigation, and that could be taken as intimidation under the statute, which says well, the statute doesn't define intimidation, but it contemplates based on the definition.
Okay, so I don't know whether you can threaten legal action or not, because there are times you can and times you can't. But for example, I think maybe it's a legal ethics question. While you're trying to settle a case, a civil case, I don't think you can threaten criminal action, something like that, I think. But let's take these sort of bit by bit. You think you can threaten someone with litigation,
All right, I think
or if they don't drop their testimony, and you think that's protected speech. Is it?
I think that it can be if your motive is pure and you're not specifically intending to maliciously interfere with.
Now I'll give you, it's just the example I came up with. I think it's fairly obvious. I say to you, you're going to testify against me. And I say to you, I will kill you if you testify against me. Now you're lying. We both know you're lying in this testimony. I am urging you to tell the truth. I can urge you, but if I threaten you with violence to tell the truth, surely that's not protected speech. That's an unlawful threat.
Correct.
So why isn't the same true for all of this? Why aren't these just like threats? You can encourage, you can do whatever, but you better not threaten, cause physical injury, promise anything of value, mislead, intimidate, harass. To me, those don't sound like they cover a lot of, well, it doesn't even matter, cover a lot of protected speech. To me, I don't think I'm not sure, that's why I'm talking about this, edge on protected speech the way incitement might, where you might say, the mayor is the worst person in the world. The mayor is wrecking our city. we have to take our city back. And a bunch of that's protected speech, and at some point, though, you might incite the mob.
I think everything you just said is also an emotional appeal, right? And we can't.
Emotional appeal, but this
Cause
says
emotion.
emotional injury. It does not say you may not make an emotional appeal.
But an emotional injury could be something that stirs, strong feelings. That's necessarily.
Injury, not giving rise to any emotion. You have to injure the person, like in intentional infliction of emotional distress. There is no intentional infliction of emotional happiness cause of action, right?
Well, we don't. It doesn't define emotional injury the way that.
I understand, but that's a separate. We'll get to that argument.
Yeah. So when we view it in context of certain instances, you could think of somebody, a domestic violence incident, where it's a he said, she said thing, and simply by approaching the complaining victim who, in our example, fabricated the charges and saying, hello, like, we used to have this past relationship, that's an appeal to emotion which could, elicit an emotional response that we could call an injury. And what's he doing other than saying, like, let's tell the truth
Why
here?
doesn't he let the court sort out whether she's telling the truth? There's a proceeding going on. Isn't that the whole point of this? We're not going to interfere with the proceeding. The person has made this allegation. It'll be judged. We hope that if it's false, that will be unmasked and revealed, although sometimes obviously it's not. But isn't that the whole point of this?
Well,
that it's not for one party to go and threaten the other to get them to, or do anything, emotionally injure them to get them to withdraw this. They've made the allegation, now there's a proceeding.
And the court may sort things out correctly, and it may not. But, he shouldn't be deprived of the ability to make legitimate efforts to reveal the truth of the matter simply because, a jury may or may not decide against him down the road, especially when that engenders all the cost of litigation, the risk of litigation, lots of the reasons that they say incitement borders protected speech, and why we need to protect it, because there's a lot of
People settle cases. They don't usually threaten people to get them to drop them, I hope.
No, but if you look at, when I say threaten, I don't mean physically threaten, and not in the term of true threats, but threaten litigation or something like that, which could cause a reasonable person to feel intimidated or harassed as those terms are defined or not defined within the statute. And it reaches that, and it chills that. And that's the problem, is that we're not simply, we're in an overbreadth analysis, and the question is whether or not sweeps beyond, and this is the
Okay,
second
so let's move into the overbreadth argument. Your argument there is that this same category of speech, this justice-seeking speech, is what is chilled. That's what's overbroad about it. It reaches some of this, or is there other speech as well?
If you apply certain of the conduct clauses, it chills a lot of speech that's constitutionally protected. And the problem is that there's
Tell me what that is. It that same speech that you were talking about before?
anything that's intended to interfere or impede a legal proceeding.
No, it has to be a threat, harassment. I can encourage you. Telling the truth is really important. This is how our society functions. You can't just go in and say something that's a lie. That will undermine the whole system of government we have there. I've encouraged you, but I don't believe I've threatened or harassed, I could do it in a harassing way, but I hope I haven't.
I think that's influencing, depending on what your intent is. I could go up to somebody and say, hey, make an earnest effort to tell the truth, and somebody could say, hey, you're just obstructing, you're interfering with our witness.
Stop. The statute doesn't say there's no way that you can interfere. It says you can't do so by threatening, attempting or causing physical harm, property damage, conveying a promise of anything of value, misleading, intimidating, harassing. It seems to me that the stuff you're talking about is already excluded from this, leaving aside the vagueness problem, which...
I think even based on what you just said, that could be considered harassment or intimidation, or an emotional appeal, depending on what the jury says and depending on what the intent that you had was.
Well, depending on what the facts are, maybe.
Were you specifically intending to have me tell the truth, or were you just earnestly approaching me because you're hoping that, I'm going to say something that's not true. And even if we're going to couch it like that, in a very polite, genteel way, it's a factual determination for the jury to determine what exactly was your purpose there. And I think that's a good example of how this could go beyond what it's intended to go beyond.
What's the best case that you have for that?
I think it's not directly on point, but the Cruz case, I think, is important. And I noted a couple times within my discussion. But again, the court says, yeah, he may have, I'm paraphrasing, but the gist of it is that the Commonwealth is interfering in the sense that they're encouraging this witness to come forward, but there's no maliciousness here because they're telling him to testify about what's true. And I think that's the problem with the statute and the overbreadth, is that they're saying, in that case, there's a malicious element to it, but that's not in the statute, and that's not in the jury instructions, and it certainly wasn't in the jury instructions in this case. It's just any intent to interfere, no matter how earnest your purpose. And that's the problem with the overbreadth of that statute, amongst other things. There's no limiting characteristics whatsoever. I think I detailed that pretty thoroughly in my brief. But.
So you're saying that as applied, or you're saying just generally? As applied to these facts?
So I think that it was unconstitutionally applied to Mr. Candello based on the points I make in argument one, but I think it's an overbreadth challenge that goes to the face of the statute.
So as applied to him, you think that he was permitted to do what he did?
I think there's a legitimate chance that the jury's verdict rested on a finding of recklessness and not specific intent, where that was, I think, most forcefully conveyed to the jury was, hey, you put aside specific intent. We think we have it, but it doesn't even matter because we have recklessness. And I think applying that recklessness standard and coaching the jury to rely on that in place of specific intent was the problem as applied. But the overbreadth challenge is to the statute itself. That should be invalidated based on its overbreadth.
And his speech here was what? Your client's speech?
Showing up, saying, hey, I want to...
Showing up in violation of the restraining order?
Correct.
And what else?
Basically pleading to let back into the house.
And doesn't he whisper to her, I know you're sleeping with a jailman?
Right.
What's the intent, or what's the purpose of that?
That's for the jury to decide, I would say, but there's innocent explanations for it, or it could further his pitch to get back into the house saying, like, let's put this behind us, something like that, but ultimately a question for the jury. What did he intend with that? I see I'm out of time, but I think just briefly the third argument is important too, because there's no reasonable standard with emotional injury. And
we have that argument in your brief. I think we understand the vagueness arguments.
Okay.
So thank you very much. We will hear next from Attorney Von Flattern.
Good morning, may it please the court. Cynthia Von Flattern, Assistant District Attorney, Northwestern District for the Commonwealth. The Commonwealth would ask that you affirm the verdict of the jury. In this case, the jury was instructed on intimidation of a witness and on both prongs, on specific intent as well as reckless. There was no objection based on countermand to that instruction, and we would submit that the standard of review would be substantial risk of a miscarriage of justice, and that standard was not met in this case where there was sufficient evidence of the defendant's intent. I would submit that it was very strong. As the prosecutor argued throughout the case, this was a case where the jury was asked to consider the context and the totality of the circumstances, where you had a defendant with an abuse prevention order in effect. His friend has texted the victim before they come onto the property, and then in a mixture of speech and conduct, the defendant, in a way that made her nervous, made her scared and upset, comes onto the property, slides down this cliff, and onto the property while the other man is still there with his car in the driveway. And then He's crying. He says he wants to get back into the house. So when there is an abuse prevention order preventing him from going to the house, from contacting her, requiring him to stay away, and the testimony is that there will be a hearing in 2 days, I would submit that is intended to interfere with the judicial proceeding.
Okay, so this argument says, if I'm understanding what you're saying here, says even if Mr. Candello is correct, and the recklessness instruction oughtn't to be in the statute, there's no substantial risk because in all likelihood, that's not the basis for the jury's decision.
That would be the Commonwealth's first, I think, and best argument.
I just want to
Good
make sure
argument. Yes.
yeah.
Yes. And a second argument would be, even with reckless, and if the court is concerned about the sufficiency or whether reckless is an appropriate basis on which to convict the defendant, that there was violence implied with the conduct, with the fact that there is an abuse prevention order in this case, and he is to have no contact with the victim.
I don't see how, if what he says is being judged on its content, unless it's unprotected speech, I don't think the fact that he can't say anything, but then you punish him further for what he says, I'm not sure the First Amendment would let you do that if it were unprotected speech.
Well, certainly, in a different context, there could be a situation that wasn't so threatening. And the prosecutor gives this example too. If he had gone onto the property and brought the groceries, which they did have groceries, and didn't have that other conduct of, coming on in surprise and screaming her name and then whispering to her about sleeping with a jail guard, that would be a different kind of content, different kind of conduct and speech.
Now, I know Mr. Candello doesn't raise this issue. Is everything prohibited by this unprotected speech? I understand that's not before us and it isn't raised, but I was surprised by the absence of a discussion of that.
So, Your Honor, is the question whether that anything that he would say is not protected speech?
No, the question is, let's say it only had the intentionality prong. Recklessness had never been written into the statute.
Yes.
Would this statute pass First Amendment muster?
Yes.
Why? It lists a bunch of things here. I know true threats can be prohibited, but it lists a bunch of other things: causing economic injury, promising anything of value. Well, okay, maybe. Intimidates, harasses.
Well, with respect to, of course, the theory in this case, the intimidation and the harassment, I think by definition, are causing a violation of justice and also scaring the victim. And so that is, and those definitions are quite specific, with that intent language, has a valid purpose, or that language.
Okay, so I was reading both briefs, and in the middle of your brief, I was surprised to find a citation to a case I had not been aware of, like at the end of a string cite, and this is O'Neill versus Canton Police Department.
Yes.
Okay, so this is a recent case.
Yes.
From the District of Massachusetts Federal District Court, in which the judge concludes that the statute is narrowly tailored to serve a compelling government interest.
Yes.
Now, presumably, you don't have to figure that out unless it's prohibiting some protected speech.
You don't have to figure it out unless it's prohibiting some protected speech. Well, in that particular case, the facts of that would at least bring into question whether there was protected speech, because there was almost like a picketing of, there was somebody who was a victim or a witness in a case, but he was also a public official, and there was, like some demonstrating that was possibly going to go on at his business premises. So that would be a case that might where there might be a question whether the statute was used appropriately. And I believe in that case that there was no prosecution of those individuals, so it wasn't really tested. But with respect to, there are many cases in the case line from this court and from the Supreme Judicial Court of intimidation based on intimidation of witness, the statute based on intimidation, harassment, threats, where the statute is I would say, perfectly valid, and the defendant has not engaged in protected speech.
If the way that I convey my intimidation is by standing with a picket sign, that's okay?
Well,
But if I intimidate them just by yelling at them when they come out on their porch, that's not okay?
I think it would depend on the result for the victim, for the, whether that, you would have to still meet the definition of whether there was intimidation or harassment, so it would have to seriously alarm that person and also cause substantial alarm to a reasonable person. So, if the person is a government official and there's some, or, a government official, local level, state level, federal level, then you would expect that picketing would not cause, it would be more in the nature of incitement. It would not cause
economic
serious alarm.
damage.
Well, economic damage, and I think that this court and the Supreme Judicial Court would be able to, if we were talking about a case of economic damage, then the statute could be challenged in a motion to dismiss before trial, and it could be challenged after trial, and that might be a question where the court could put a limitation on the statute on that particular phrase. The Commonwealth is not aware of a case where intimidation of a witness based on economic harm was upheld. There could be, but I'm not aware of it, and I think that might be one that's questionable, but maybe not, because one can really think about, a case where you have, it could be a civil case, it could be a criminal case. If somebody is going to threaten economic harm based on your role as a witness or a victim, that would be very intimidating. So, if there was incidental harm because you have a business and somebody's picketing outside, that's far different than a threat because you are a victim or witness that really causes you to lose or causes you to have economic harm or a fear of economic harm. And, in this particular case, there was no challenge to the statute, no claim of vagueness or overbreadth. So I would submit that it is not, the facts are not good for the court to really have to worry about the outer limits of the statute.
Well, there is an overbreadth challenge. I know it wasn't raised below.
Not raised below, but it is raised here. But I would submit that it was not raised below. The standard is substantial risk, and that given that as applied to this defendant, the statute is not overbroad and not vague, I would submit that this is not the appropriate case for this court to decide that the statute is overbroad and vague.
Can an overbreadth challenge ever, the failure to bring an overbreadth challenge, can it ever cause a substantial risk of a miscarriage of justice? That is, you're always talking about some third party's standing, right? It always has no literal bearing on the case. The point is someone who's done something even illegal can bring this challenge.
Yes.
Can that cause a substantial risk of miscarriage of justice? If they brought it up and it was correct, of course, they would have won the case. On the other hand, it doesn't mean they didn't do it.
I think the case law says that even when not raised below, that it is such an important issue, such an important right, that it can be dealt with on an as applied or on a facial basis, even if not as applied. But I would submit that there are many cases where the statute has been upheld.
This statute from constitutional challenge?
Well, not as a well, I would submit that the case that's cited in the Commonwealth's brief, Frazier, talks about a constitutional challenge. That was on a motion to dismiss, and that was a Rule 23 case. So I believe that.
So it's nothing except persuasive.
It was dealt with there, and there have been challenges to the terms of the statute, and this court has been able to say what constitutes intimidation, you know, and in terms of the vagueness argument, I think that the vagueness argument is weak because this statute, the terms have been defined or they have been defined by the court.
Well, not emotional injury, right?
I'm sorry?
Not emotional injury.
Emotional injury, I would submit in this case.
I mean, I don't know if it's vague or not, but there's no case saying what it exactly doesn't mean or mean.
I think that emotional injury, we have other cases, for example, criminal harassment that talks about, you know, you can define, this court can define emotional injury. I would submit in this case, there was no question about emotional injury because the testimony was that she was afraid, confused, upset 24 hours later and reported it to the police then. And also, I think emotional injury is really duplicative of intimidation when you have theory of, you know, intimidation of a witness by intimidation or by harassment. I think emotional injury will result, and so it's somewhat duplicative. But I think that is a good example of where this court could graft a definition of emotional injury onto the statute, and without harming this defendant, because emotional injury, wherever the outlier is, was shown in this case. If there are no further questions, Commonwealth would rest.
Thank you very much. The case is submitted. We are going to take our traditional mid-morning break. We will return in 10 or 15 minutes to hear the remaining 3 cases.
Court is now in recess.
morning again. We continue our session with our next case, which is number 251224. Excuse me. This is Department of Children and Families versus Mother. It's an impounded case, so I just remind everyone we're going to use words like child, mother, maternal grandmother, rather than anyone's names. And we will hear first from Mr. DeJoy.
Thank you, Your Honor. If it please the court, my name is Mark DeJoy. I represent a 19-year-old mother who was 17 at the time of trial, the first day of trial. She turned 18 within the trial. I would suggest, Your Honor, that the trial court thought this was a close decision. If you look at page 2 of the findings, I'm not going to read the entire paragraph, but she says, I was going to give mother an A for effort in ordering the return of the child to see if she might be able to meet the needs of the child. I would suggest, Your Honor, that closeness that the judge describes requires that she also be specific in details as why she chose not to render a decision that the mother was fit. The sad facts about this case, Your Honor, is that mother at 12 and 13, I might say, Your Honor, I apologize, I believe mother is watching at home. I'm sorry, I should have said that earlier. The sad facts are that mother was sexually assaulted at 12 and at 13. The first one, when she was 12, she met the gentleman the first day, didn't know him prior. The second gentleman was a pseudo-uncle, according to her testimony. She testified that, while 17, that the putative father, the perpetrator, said kind and loving things to her. She says this while she's 17 on the stand, questioning by one of the lawyers in dealing with explaining what was going on when she was 12 or 13. And I think
as you stand here right now, do you think that mother has some mental health issues?
Well, I think she had mental health issues, Your Honor.
As you stand here right now, do you think that mother has presently some mental health issues?
No, Your Honor. No,
So no PTSD, no trauma associated with her childhood, I'm going to call it childhood, but no trauma as a result of some of the things that she had to deal with in maternal grandmother's home.
I misunderstood your question. Absolutely, she had PSD, anxiety, whatever.
Suicidal ideations, do those still exist?
Those existed at some point, yes, Your Honor. The judge went back and used Dr. Clark's report and pretty much says at least seven, I'm guessing seven findings, which she says, Mom, she says 9 months before the trial, I apologize. Mom has got her footing. She's doing well. She's engaged. So from 9 months forward, she may still have that trauma that you discussed, but I think she's addressed that trauma because the judge points out she has no hospitalizations. You want to move on? I just don't.
No, go ahead. No, I understand that.
Okay.
I get that.
But
during that window, was Mom the primary caregiver?
no.
No.
Well, Judge, she's 17.
I understand. That cuts both ways.
It does cut both ways.
Do we take away children from children who have children? None of them can care for the child by themselves. Does DCF just come in routinely when someone's 14 and has a kid, take the kid away?
No, Your Honor.
Okay, but the kid goes to school, maybe middle school, and the kid lives at home because they're 14. But these aren't reasons to remove a child from the care of its mother, right?
I would agree, Your Honor.
Okay.
Right, but that's not the facts that we have here. The facts that we have here is if if mother is in school, then the child is going to be with the maternal grandmother, and the maternal grandmother's home is the home in which mother was subjected to the trauma that we're talking about. And it's maternal grandmother's home. Doesn't she have a brother also? Doesn't maternal grandmother also take care of another special needs person in the home?
A son, yes. Your Honor, but I would say the first day of trial, while mother, in this case, was a child,
Sure.
that case was dismissed on the first day of trial before any testimony. So at least DCF, at some point, notwithstanding what you just said, and there's not anything I can disagree with what you just said about the history there, but DCF dismissed that case, took the 17-year-old and put her back in the home.
Well, it was dismissed because she was about to turn 18, correct? I mean, that has something to do with her age and what she is, her development. But, I mean, how can we ignore still that the finding, because you don't dispute any of the findings specifically. You're disputing the conclusion, correct? And so how do we square that with the finding that it's the grandmother's home that was and continues to be insufficient support for mother?
I understand the question, and I'm not sure there was much evidence, other than the bad things that the grandmother did when she was 12, and then there was another boyfriend of the grandmother who had sexual. He's a registered sex offender. I understand all that. I don't know how, though, that. Going back to what the judge said, if mom could do it, it's not the best place to put a 17-year-old child, but they did, and they dismissed the case, Judge. I know maybe a month or 2 months, but they did dismiss the case, and the record would show that grandmother had changed her ways of being.
But that's not why they dismissed the case. They dismissed the case because mother was about a month from being 18, and mother wanted to be with grandmother.
Correct. And because Judge,
Did the judge take any evidence on the current state of affairs at the maternal grandmother's house at the time of trial?
I do not believe so, Your Honor. I only can assume, that's what Justice Allen, I do agree with her, but it may have been a 30-day window, but
I'm not interested in the dismissal part. I'm talking about whether it's safe for mother to have the child if she's living in the mother's house. I mean, what I'm really concerned about is this indefinitely into the future part, right? Because
Inclusion law number 23, Your Honor, I agree with you.
And, to say she behaves in a childish manner and lives with her mother when she's a child doesn't seem really particularly remarkable to me. Children are childish, and they do tend to live with their parents, no matter how bad they are. That doesn't make it a safe place for the baby or child right now, necessarily. It's not a baby anymore, but for the child right now.
But if that was...
when I was 17, I lived at home, and then when I was 20, I didn't, or whatever. I'm not to compare the situations. I don't know what the future holds. Well, you do, to some degree, know what the future has held for the mother.
If I might address that, Your Honor, that is, my sister from the department stated on page 47 that I mischaracterized the record. I don't think I mischaracterized it. I think we have a disagreement at what the judge said, because the judge said at finding 15, mother is internally conflicted whether this was a consensual relationship or not. The information came from the mother's testimony, which she said described what happened at 12. What I have problems with the finding, Judge, at 23 is that she takes a present testimony about a past event, right? We're looking at current unfitness. The kid went through a lot at 12 and 13. Current unfitness, and then the judge then turns around and says, and by the way, I can't determine if she can protect this child in the future. Because, Judge, and she goes back, to be exposed to people who are not safe or appropriate, tied to the adults when she was a minor. My words, 5 years ago, in lacks insight to protect the child in the future. That is a bridge too far for us to determine what can happen. Would anybody?
Well, I don't think it necessarily follows. This mother has been, and she was a child, has been through unbelievable, outrageous treatment and trauma. So she's raped when she's 12 and gets pregnant. Does it surprise me that, I'm not a shrink, so I don't know what surprised me actually, but does it surprise me that she might have believed or told herself that this was a love-based relationship because she'd been groomed? That doesn't surprise me. It doesn't make it a love-based relationship. It's rape. And flat out, it can't be consensual. It is rape, and it's outrageous. She's a 12-year-old. Now, must she necessarily, 5 years later, with this child in her life, conclude, no, there was nothing romantic between us? I don't know. She may, I mean, I don't know what's a coping mechanism. I know I'd like expert testimony on this question. I take it the department and presumably the child's position is maybe it doesn't matter. If she believes a 12-year-old can have a consensual or romantic sexual relationship, how can she care for a child? But I take it that, right, it's that leap that you think is too far.
And I'll go back to what Justice Desmond said. Whatever trauma she had, no, she went through a period where she was going to hospitals and bouncing around to different group homes, right? It seems that she came out of that. But I don't think when she's 25 that trauma is not going to exist. Whatever she's experienced, she's experienced. There's nothing any of us can do to help the mother with that. It's the judge's strident way of saying it that I do not know how. I do not find the findings of cases so close that says all the questions we're asking ourselves. What evidence did the judge use to find that? Despite the 9 or 10 good things that she did, the judge followed Karen Clark, the expert, followed all the way and goes, oh, not the determination. And I suggest, Judge, that and my sister's brief is right, the judges granted due deference. But that doesn't come before the specific facts of how I got there, or how the judge got there. And I think the mother owes, judge owes that.
You would agree that Dr. Clark's report was quite deficient in that mother did not respond to many of the questions, correct?
Yes, that's correct, Your Honor. And she also...
She just didn't answer questions about anxiety or just didn't answer questions about depression. And then Dr. Clark took that non-response and said, well, then she doesn't have, she's not suffering from those things. I think that you don't think that the court is entitled to deference to not adopt that.
Certainly by the preponderance, yes, Your Honor. I would agree with that. But she was the only expert in the room. She wasn't a mental health expert by any means, but she was a parental capacity. And the judge had that sitting with her, and if she didn't agree what it was, I think what the judge's ultimate finding was, against the determination of Dr. Clark, was that mother had a past mental health abuse, may not understand the needs of the child, and this misunderstanding or misguided understanding what that is. I think this has been the through line in this case, because nobody wants to put that child, or any child in this case, back where a mother doesn't have the ability to protect that child. But we can't guess that. There wasn't evidence presented, excuse me. Well, there wasn't evidence presented. She certainly didn't articulate that as to why she
I know this is outside the record. Does the mother still live with the maternal grandmother?
I don't think so, Your Honor. How about this, Your Honor? No. I believe I know where she lives, and I don't think it's here.
Okay.
That was one of the primary concerns by the judge, right? Was not just the challenges that mother faced, but the environment that mother was, her plan included, which was going back to the maternal grandmother's house. And so in that home, you're going to have the brother who has special needs,
Yep.
the child who has special needs, the mother who has challenges. I don't know if I'll call them special needs, but certainly extensive challenges that remain today.
Right.
And maternal grandmother whose decision-making at best is questionable.
I would only say, Your Honor, at one point in the past, I would agree with that. I'm not
And
vouching
so
for the paternal
the judge
grandmother.
determined that it wasn't in the best interest of the child who has extensive issues and is going to require extensive care. I forget how she put it exactly. But his developmental stability was contingent upon intent. I'm stealing some from the, I think it's child's brief, parental intervention, and that mother, do you think mother's capable of caring for child
Yes,
today?
yes. I can't go outside the record, Your Honor, but the answer is I'm down to 1 minute. But I do, Your Honor, I would just say one thing, Judge. The lower court judge was very close to coming up with, she could have conditionally returned the kid home after she moves out.
Well,
Judge.
there was a lot of talk, though, about the trauma the child would undergo with separation from the stable placement. I know there wasn't expert testimony on that. It wasn't the sole basis of the decision, but it was a heavy basis of the
We
decision.
can all agree with that, Your Honor. I would expect that in most cases with this time frame. I can't quarrel with what you just said.
Do you think that mother's improvement is in part because child has been with the adoptive family for the last 2 years?
I can't answer, Judge. I wish I could. I couldn't. But what I can say is that she did everything she was asked to do 9 months or so on the way. She did things she wasn't asked to do. So,
That's true. I think that's true in many respects.
but I don't have an answer.
But
to
is that
question.
enough of a sample size when we're talking about the best interest of the child?
Yeah. Judge, we try to, as trial lawyers, we try to squish this time frame as fast as possible because every day beyond a year, 2 years, no matter what the parent does, generally, the judge has to do what Justice Rubin just said, because rip this kid out, he or she has more problems going forward. So I don't disagree with the premise.
The judge said that mom's not able to plan for unforeseeable circumstances that may happen in the home, which could arise given the special needs of the child. Couldn't plan for how she was going to get to medical appointments or document conversations that she had with medical providers for the special needs child.
I don't think mom's alone in that position. That parents who are 17 years old have a child who has special needs. They work it out. Maybe the department doesn't think mom's equipped. This mom is equipped to do that. I maintain the judge didn't have evidence to say whether she could or not, other than what she did, getting to the visits and everything that she did, the bonding with the child. So, yeah, there's this gray line while arguing this. I can't answer many of the questions you have, Judge, and I just...
And this is not to say that mother does not love child and mother does not have a bond with child.
I think that was found, too.
I think everybody recognizes that's to be the case. The judge did by ordering visitation, so it's not as if the child won't be in mother's life.
Right.
Mother was advised not to have, I think I forget if it was a former foster parent or foster care provider
Misguided.
exposed to the child. But she did it twice. She once invited the person to be there, and then after being told don't do that, she got him on Zoom or emailed him or somehow other contacted for the next visit. Both instances dysregulating the child.
Despite the department telling him not to do the second one. I don't disagree with that, Your Honor. I'm not.
Your time has expired, but if there are more questions, I want to
Thank you.
thank you, and thank you for the extra time, and if the other side needs some extra time, we'll happily give you the same amount. I gather you're dividing your time 10 minutes and 5 minutes?
Correct.
So we will hear next from Attorney Specht.
Thank you, Your Honors, and may it please the Court. Assistant Attorney General Claire Specht on behalf of the Department of Children and Families. In this case, the trial court made detailed, careful, and extensive findings of fact and conclusion of law in determining that clear and convincing evidence supported terminating mother's parental rights because she was unfit indefinitely and it was in the best interest of the child. I want to start with the child's profound special needs. The child has severe autism that requires a heightened level of supports.
You say severe. I didn't see that in the findings of fact. I'm not saying it's not serious, but you in the brief and now here have said severe. There seems to be a lot of evidence of the child communicating, and indeed ABA services were found, admittedly after the child went to the pre-adoptive placement at the time of trial. The child didn't need ABA services anymore. So I don't know, I'm not saying it's not severe, I'm just saying I just didn't see in the record.
I believe there's a finding that he has autism. I think there also was severe, and the testimony that the trial court judge referenced also talks about severe autism. I believe that came from some of the social workers from the department. But Justice Rubin, to your point, the improvement that the child made being in the pre-adoptive family's home is because of their recognition of that child's special needs. They are very consistent in a schedule with the child. They prepare him in advance for any changes to that schedule that will happen. They develop their own fruit-based language to allow that child to communicate and facilitate communications about that child's special emotions and what he was feeling. And they also engaged with communication so that the child could explain his emotions and what he was feeling. And while in-home service ABA services were no longer required, there were still non-in-home ABA services that were determined to be needed. And the evaluator in doing that specifically found that it was these supports that were in place by the pre-adoptive parents that led to that. And there is a finding by the trial judge that it was hard to get services in when child was with mother alone.
Is the child still in that placement?
It's outside the record, but yes, my understanding is the child is still in that pre-adoptive placement.
As I said to your colleague, the only question I have about this, it sounds as though mother was not fit at the time of trial. There has to be clear and convincing evidence that that would continue indefinitely into the future. And she was 17 and still in school and living at home and had complied with everything that was asked of her and more. And although can't anticipate future, unforeseen events or something is absolutely a serious finding, when she was told how to do things, she learned and did it. How far in the future counts as indefinite? You know what I mean? I mean, if you brought this petition when the child was, shortly after the child was born, you'd have a 12-year-old who certainly isn't fit to raise a child. It'll certainly continue that way for several years, at least, into the future. But I don't know if we'd say that's indefinitely into the future. We don't ordinarily take, unless you tell me otherwise, I don't think the department ordinarily takes the children of girls who are sort of by definition victims of rape or other sexual violence away from them. Is that right?
It's correct that there's not a universal issue. I would point this court to adoption of Inez, which says we can't wait for parents to mature. We have to consider the best interest of the children, regardless of whether the child who gave birth to the child as a child themselves, that there are attendant concerns that are waiting, and that we can't wait for the best interest of the child. At some point, enough is enough. And I would also point this court to adoption of Darlene, which is cited in Mother's brief, because I think that is very factually similar to what we have here. In that case, the mother had a history of psychiatric hospitalizations, just like we have here. The mother admitted that she would need a lot of help in taking care of the child, just like we have here. The mother in that case was able to implement suggestions made by social workers, but could not come up with her own solutions on her own, just like we have here. Mother never progressed to unsupervised visits, just like we have here.
How old was the mother in that case?
I don't recall off the top of my head, Your Honor, but I know that she was psychiatrically hospitalized when she was around the mother's age. That was factually in the case. The child regressed after visits, just like the child does with mother here, and the child was bonded to the pre-adoptive parents, just like we have here. And this court affirmed the trial court's termination of parental rights. We have the added factor here of the concern about unsafety in the grandmother's home. That's in conclusion of law 13, footnote 25.
The department allows 2 other children to be in the apartment, a girl and a boy.
So my understanding is both of those children are over 18 years old. We are not dealing with a child.
That you believe that the children of the...
Their mothers.
Yeah, well, this mother's over 18 also.
Correct.
So I'm just asking you, the department has not removed another little boy and little girl who live there.
Not to my
But here
knowledge.
you say it's too dangerous for a child to live there.
I'm not aware of another case involving the mother's sister and her children, but that being said, we have a child with special needs. My brother does not actually fight the conclusion that it's unsafe to be in grandmother's home, so that is waived. But even setting that aside and taking what he said now, where his mother's no longer living in the grandmother's home, we still have the conclusion that she would depend significantly on grandmother for assistance with the child. And so even if she doesn't live there, she's potentially going to be in grandmother's care while mother goes to school or does other things, or to facilitate that sort of
No, but I'm asking, we need clear and convincing evidence. And you haven't removed these other children from that house, suggesting, and you know they're there, right?
I personally do not, Justice Rubin.
Well, I think it's in the facts.
There
I don't
could
know
have
that they're
been
there
other
right
facts.
now, but at the
Correct.
time of
Correct.
trial,
At
I
the
think
time
they were there. Yeah.
It's also a different mother, right? So that was her sister. There was also testimony in the record that her sister was the one that did a lot of the caretaking for mother's child when mother was in foster care, along with the foster mother. So there are different parents with different children and different set of circumstances. We have to evaluate this based on the parent that we have in front of us.
Well, the
along
risk
with
of sexual abuse in the house probably isn't different, if that's what the risk is. I don't know if that's what DCF considers the risk to be. That looks like the risk to me.
I think it's a broader risk, Justice Rubin. It's unsafe individuals potentially being in the house. Yes, that was sexual abuse, but it's also related things. Grandmother in this circumstance has a long history of mental health issues of her own that led to mother herself being removed from the home. We also have the brother. So we're in a situation where the mother's planning on relying extensively on grandmother to provide support and care for this special needs child. Apart from everything else, we have to weigh how that presence of that individual and what could that child be exposed to. There may be a different plan, or there's a different arrangement with the sister that's outside the record, and I don't know. But for this particular case.
So was the linchpin then that mother testified yes, I'm going back to my going back to my maternal grandmother's home. Is that the sort of binding fact there? Not her age. It is that she was going to go back to that home and rely on that person. Is that the linchpin?
I would say it's relying on that person. I think it's together, but I think if you took her out of grandmother's home, the still reliance on grandmother, because that would still be involved and probably be involved with the house, they kind of still depend on each other. So the ultimate finding was I remain gravely concerned that if mother's mental health deteriorates, which it's likely to given the delicate state that it's in, given the additional stressors of parenting a severely reactive autistic child, that's at finding of fact 118, that I have concerns that her mental health will not be able to cope with it. And if she cannot cope with the child and her mental health decreases, she is going to be left, the child is going to be left in the grandmother's care, and I have great concerns about the danger that the child will be exposed to by being in grandmother's care.
So at the end of the day, does her age matter at all?
Not under this court's precedent, no. We hold parents to the same standard. The child is, allowed to have a predictable, stable upbringing, and we don't kind of let the age define that. That's adoption of Inez. And then I would say mother did have time once her mental health stabilized to show that she could care for this child, and the evidence clearly shows that she cannot.
What if mother had testified, yes, I'm going back to my mother's home for 6 months, but I have a plan that I'm going to get in touch with services, I'm going to get into an apartment, I have a plan for a job into the future. Do you think that would have made a difference?
That would be a closer call, Justice Allen, but I do think given all the other factors that we had here with this child and the mother's history and everything else, and she engaged with services and over, the trial court said, yes, I applaud you, you engaged in services, but there has not been any corresponding improvement in parental ability for this child and for meeting this child's special needs. So I think even if she had testified to that fact, on the facts in this case, there would still be clear and convincing evidence to terminate parental rights.
Did mother submit an action plan? Did mother submit a plan of some sort that suggested that she was going to get a job, and when she worked, the child was going to be in the care of the grandmother, and I think mother was going to get a job and go to school, actually. And during that period, she was going to have the child in the care of the grandmother, and I think mother planned to do her homework maybe on the lunch hour of something. Is that a realistic plan?
Not in the department's view, it was not a realistic plan. It requires an idealistic view of what would happen, right? I'm going to go to school in the morning. I will then have a job in the afternoon. I will do all of my work for my college courses during the break. I will then be released from the job that I have in time to pick up and be there for my kid from daycare. And then I will be able to care for him until he goes to bed. And in the meantime, he'll be with grandmother. That's not, given this child and his special needs and unplanned circumstances that happen around it, it's not going to be this curated, this will happen and this will happen and this will happen. I would submit that that's just not realistic for how parenting this child would proceed.
Can a mother be fit as to one child and not fit as to another?
Yes.
All right, your time has expired. Thank you very much. And we will hear last from Attorney Collier.
Thank you, Your Honor. Attorney Shauna Collier on behalf of the child. This case turns really on child-specific determinations, and this child's really heightened specific needs, and this mother's unfortunate inability to meet those needs. And I think that when you were discussing the other two children in the home, that sort of belies the major issue, is that mother's older sister, who was in fact taking care of my client while they were in the foster home, the first foster home, and doesn't have those limitations, and her children also don't have special needs to the extent that my client does. My client really does, he has the autism, he has other medical needs, he's seen by a lot of providers, and he really needs a parent that can manage all of those things. And so while being out of grandmother's house may relieve a safety concern, it also then raises the concern that mother herself was relying on her mother to make many of the plans she was asked about, providers. She doesn't keep track of her own providers in a way that she can access them. And so, you know, she was when discussing what would happen with having the child home, she would repeatedly say we, meaning that she was still anticipating her mother would do the primary caretaking.
Well, she's a 17-year-old in high school.
Yes.
I think most 17-year-olds in high school would say that.
And maybe most 17-year-olds in high school wouldn't be able to take care of a child with this heightened level of special needs that requires this much proactive care. And certainly mother has additional limitations. And so it is a case on crux of, you know, this particular child and this particular mother and her inability to meet his needs. And the judge made, we were in trial for 6 months. There was 6 times, close to a year, made 199 findings. It's exhaustive. And with all of that, she found that, and none of these findings are being disputed, so they are taken as fact at this level. She just said that she couldn't safely meet this child's needs.
How long ago did you see your client?
I saw him at the end of March.
In March? Face-to-face, in person?
Yes, in person.
And is he in the same placement he was
Yes.
in before?
Yeah.
It hasn't disrupted in the interim at all?
No, he's doing great. And I wanted to speak to that too, because I don't like when we compare foster homes to biological homes. They usually are bigger and have more money and all of those things. But the court can look at the progress made while in that home under the adoption of Lisette. And specifically with the ABA services, the way that the in-home ABA services work is that they come in and they work with the parents to teach them how to manage dysregulation and scheduling. And because the pre-adoptive parents had actually invented some of their own skills, particularly the pre-adoptive mother, with regards to speaking about feelings in terms of oranges and strawberries and being able to help him learn how to dysregulate, that the in-home ABA wasn't needed because they were already doing the things that they would have been recommended by the in-home ABA team. I'm sorry.
Can I ask you the same question that I asked your colleague? Does her age matter?
No, it doesn't. You know, it's unfortunate that that younger people are at a disadvantage, but here it's the best interest of the child that are really taken, and because childhood is fleeting, they need, especially this child who really thrives on a sense of stability and permanence, needs this stability, and that's why it wouldn't be fair to him to just keep going and keep trying and see if it changes. I mean, he deserves stability. He's 6 now, and he's still in limbo. So if there's no further questions, I would just say that this case is about mother's inability to make progress enough to sufficiently meet this child's needs despite participation in services. And the judge made those findings, and they're supported by the record, and the child respectfully asks this court to affirm the decree. Sorry, this is my first one, and I'm a little nervous. Are there any further questions?
Thank you very much for your argument. The case is submitted. The next matter we will hear is number 25-529, CK versus SH. This is partially impounded, so we're going to use initials for the parties or plaintiff defendant, and to the extent other people's names might have identifying information in them, we're going to use titles or whatever. So we will be hearing from Attorney Goldwyn.
Thank you, members of the Appeals Court. Stephen Goldwyn, the pleasure of representing the plaintiff relative to this appeal. I'll start by sort of saying it's difficult to prove a negative, but I'll do my best. The gravamen of the argument is that never at the ex parte hearing of the restraining order, at the initial two-party, and ever increasingly at subsequent extensions, was there an understanding also that an abuse of discretion is the standard. Even by that standard, there was no, could not be a finding that there was a reasonable fear of imminent serious physical harm. I'll lead with what I think is best and brightest, which is the imminency.
Can I just ask a question? I was a little confused by your brief because it seemed that you were arguing that you were looking for us to vacate or reverse all of the orders, but the gentleman did not appeal timely the orders from 2023 or 2024. So would you agree with me that those are in place and cannot be appealed? And if you're going to disagree with me, what do you rely on? Because
I'm going to disagree.
Okay.
And I'm going to...
Well, you're going to need a case then.
Well, I'm going to rely on the following. And I did anticipate this question, and I'll do the best I can. Firstly is, I believe, whether it's Rule 60, Mass Rules of Civil Procedure, or this appeals court, there needs to be, common law or otherwise, a catch-all discretionary power on behalf of your honors.
Did you bring a 60B motion?
I'm sorry?
Did you bring a 60B motion with respect to the first judgment?
We did not. I mean, that would have been
For the second judgment.
on neither. I mean, that, again, would have been a year or two late as well.
Well, that, I mean, okay.
And I suppose that could be done tomorrow and come back in front of your honors in another year.
Although, of course, yes.
But the point being, if you can envision the most frivolous case that existed in the civil world, I actually today, this is far afield, but it's what I have. It has to do with the Masters. I remember somebody 20 years ago as a prank, the Ox was his name, filed a complaint to deem himself the Masters golf champion. Something just so clearly a nullity, frivolity. And they did, believe it or not, respond to it, and he backed away. But envision a world where somehow or another that gets tossed in the garbage, he proceeds to judgment, execution, and you have it there. There has to be, and this clearly isn't nearly as egregious or silly as that, but I believe there's some inherent power in this appeals court if you find the initial order is, in a sense, a nullity or a frivolity and wasn't supported, that the mere procedural time constraints can be overruled.
Maybe in a criminal case. But
understood,
maybe.
Your Honor. The second argument,
But let's
also don't
assume
have.
we conclude that all you can challenge is the current extension order, and that extension order, this is the 2025 order. What's your, argue that case?
It does, I think, piggyback on the initial order.
It can't. The initial order, as I understand the law, and I've heard what you've said, we'll go look, but I haven't seen a case like this. The initial order we have to take as correct. All we can review is there sufficient evidence, if that's your argument, that supporting the conclusion that she remains in reasonable fear of
Right.
imminent serious physical harm.
Right. I don't see how you can analyze that without at least partly looking at the initial.
You can look at the affidavit, I suppose.
Right.
But
Well, I'll include the affidavit, which was part of the initial finding, and again, turning either to the imminency or the serious physical harm or the reasonable fear. I think all three are blatantly missing.
So let me just, let's try to talk about the facts that we have right here, okay? So the defendant had a relationship with plaintiff's mom.
Yes.
Right? And had made some threats, I want to say in Canada, as to mom. This was before the daughter came to her school here.
Yes.
Okay. And in that incident, the defendant threatened mom in the daughter's presence. Or abused mom in the daughter's presence.
I thought punched also, right?
Abused mom in the daughter's presence.
And I think the punching incident, which I was going to get to, was the most recent event. It happened on January 15, and she didn't witness it. She was
January
in another-
15 of 2025.
No, 23, I believe.
So it's it's before the first order. Okay.
Right.
Okay.
So January 15th, 2023, she was in the room next door. It's very unclear what it's clear she didn't observe it. What's unclear is,
She testified that she heard him punch her mother in the
Right.
face.
I don't know if that meant he literally heard the punch or heard that he punched her.
Let's say it
But
doesn't
either
matter.
way-
The judge found it credible
Right.
and issued an order.
Right. But either way, the judge found credible that she heard, whatever that means, in the next room, him punching the mom on January 15th. She didn't go to the court until March 3rd, 6 weeks later, which, by the way, at which time he was in Canada. How could there be any finding of imminency, either by...
What prompted her to go to court?
Sorry?
What prompted her to go to court 6 weeks later?
I don't know.
Well, what about his threat to come to Massachusetts?
Well, it wasn't really a threat. I think what her statement was is actually the opposite. It was, I know he's, even putting it in a light best to the other side, she found out he was angry, just in a vacuum. She heard that he punched the mom in the face, and then she heard, again, I know hearsay can be part of a restraining order. It doesn't mean it's reliable, but putting that aside, she heard that he still considered her his daughter and was considering visiting her. And I think she even made the statement, it's in her affidavit, in fact, due to his past and recent behavior, I fear for my safety that he'll come to Cambridge with the objective of seeing me with less than good intentions. So even taking that and reading between the lines, where's the fear of serious, imminent physical harm?
And now that's for the most recent extension? That he...
No, that was in the affidavit
That was in
initially.
the original affidavit?
Right.
So she gets a restraining order on that ex-party representation?
Right.
They have a hearing, he doesn't contest the first extension?
Right.
They have a hearing, he doesn't contest the second extension?
Right.
Now we're here on the third?
Either the...
Third or
correct.
fourth?
Third or fourth.
Okay.
Correct.
But this is the first one that he actually contests,
Correct.
right? All right. And so the question now is, does she remain in reasonable fear of imminent bodily harm?
Right. And I don't think there was any probative evidence. It essentially was, as it had been.
During the 3 or 4, I apologize for interrupting.
Oh, go ahead.
During the 3 or 4 years that the order has been in place, has she had any contact with him?
Zero.
That's because there's an order in place, right?
Right. Well,
Okay, so-
at a minimum that, but at a maximum, he did state he had no idea where she was. She had been moving around, no idea.
He has no idea where she is. He knows where she goes to school, I bet.
But I think by the last one, she had moved. I'm not sure, Judge, on the last one, but not even to the heart of the matter. The point is, there was no contact between them. Admittedly, there can't be. It's a catch-22 because of the restraining order, but there was really just even no analysis by the judge. It was simply, is everything in your affidavit true? Are you still in fear? Okay. But no reasoning or conversation about it. And again, I do think it's important where there never was in the beginning, from day one, a reasonable fear.
Well, the judge says that he credits the threats to come to Massachusetts, the threat of that she was a precipient observer of physical violence, and that the physical violence occurred, and that he credits the affidavit.
Sorry, Judge, you're looking in the affidavit?
I'm looking at the transcript. Based on the testimony, I credit, which includes the testimony that I've heard, which I credit, including threats to come to Massachusetts, and the testimony regarding the physical violence and the plaintiff's percipient observations. I'm satisfied the plaintiff has met her burden.
Right. But when you look in other places, either the affidavit or the transcript, the percipient witness part does only, it's questioned, I don't have it right in front of me, but it's a very short submission to your honors. The only percipient witness aspect is that she was in the other room and heard the punch, and the only threat to come to Cambridge was what she wrote in her affidavit. I think something, well, no, it's in two places. One, the end of her affidavit, but otherwise.
What was the threat specifically to come to Cambridge? What was it?
It wasn't a threat. She might have called it, or the judge might have called it.
What was the language that she characterized as a threat?
It was, in my opinion, it was that she interpreted, there was no threat.
Interpreted what?
That he's angry, that she was the percipient witness, and that he has said that he still considers me my daughter, and he may come to visit me in Cambridge.
He has said that he may come to visit me in Cambridge?
She said that she heard that, but he never said that to her. She only heard, we don't talk about where, who, nothing. She heard that he said to someone else that because he still considered her his daughter, he may come to visit her in Cambridge. And that, not a threat, that verbiage, coupled with the fact that he was generally angry because divorce was going on.
At the mom.
At the mom.
Well, I mean, all I can see here, this is at Record Appendix 53, and it's the current hearing. Her testimony is currently they're undergoing the divorce process, and it's going to court, and I'm very worried that he's angry about it. But I also know that he said that he would come down here. That's just to my knowledge. And that he told our neighbor how he would kill my mother. So I'm just a little nervous. Now, if that happened recently, why isn't that enough?
Because it's not directed to her. There's been no indicia, zero, that has any indicia that he's ever made a threat to her, that he's ever been violent to her. There is evidence he's been violent and angry towards the mom, and if the mom was the one taking out the restraining order, it would be a different conversation, but I don't think you can make that leap that just because she may fear it, that 1 + 1 = 2, there's just no probative evidence that in any of the records that gives her a reasonable fear that he would do something to her, particularly with serious physical harm.
He said he would come down here. He's not invited. That seems pretty clear, right? He said he would come down here. So someone's coming down who is a violent person, allegedly and found by the
Okay.
court,
Yep.
comes down, is against your wishes, shows up at your college apartment or dorm, whatever, I don't know. You've heard him, or her current testimony is that she was in the next room when he punched your mother. He's described to a neighbor, you say, in the court credits, that he will, the way he'll kill your mother. You don't think that that would reasonably put someone in fear?
I just think it's too tenuous and too loose. I mean, could you then take the next step? Let's say it's not the daughter. Let's say during that punch in the face, a neighbor happened to be having tea in the room next door, heard the violence, is also in Massachusetts, so if he's coming here, I get there's not that last part where coming to Cambridge, going to visit you, but we're really...
That's not, there would be no standing because there's not a family relationship. And we have plenty of cases that say that children who are in a home where there's domestic violence are impacted by that, correct?
Right, but domestic violence, I mean, this is allegedly one punch in the face that she heard about.
That
period.
seems adequate to me.
And pointed a gun at her mother also, correct? Wait, and there was
And told a neighbor how he'd kill her.
Just going back to the original order, the question about why she sought the order in March, he was released from on a criminal domestic issue, correct?
Canada, yes.
In Canada, and there was an order of conditions on his criminal case that was a stay away from the plaintiff, correct? Immediately prior to the March 3rd, 2023 ex parte
Not
order.
immediately prior, maybe
2 weeks.
4 weeks, something like that.
Maybe February 19th,
Right.
maybe, okay.
What is the evidence in the record that he said he would come to Massachusetts against her wishes?
Her who?
Her, the person who has the restraining order, the daughter.
I don't recall that.
Is there evidence in the record that he said he would come against her wishes?
I just don't recall that being in the record. I'm sorry.
Oh, I don't understand. If the evidence is that he said he would come down here and she has a restraining order against him, it's inherently against her wishes.
But this was before the order.
I don't know when it was. In the 2025 hearing, she just says.
Well, that's right. We don't know. I mean, that's what she said in her initial...
Did she say that in the very first affidavit
Right.
at the ex parte hearing?
I think it's the last sentence in the affidavit. Due to his past, I fear for my own safety he'll come to Cambridge despite his release conditions. So at the time, on March 3rd, she knew that he had release conditions, but she was afraid, without further explanation, why she felt he would be coming to Cambridge with less than good intentions. That was the way she described it, not he's going to commit serious physical harm to me. Maybe that he'll disturb me against my wishes and talk to me or talk about my mom, that she had less than good intentions.
Well, look, if someone credits that he says he's going to go see her and there are conditions of release that prohibit that, that seems pretty scary.
And again, Judge, I'm sorry, we're talking from the 25?
I'm now reading the 23 one where she says that he will come to Cambridge with the objective of seeing me despite his release conditions with less than good intentions. So when this was done, the release conditions, of course, were in place for some number of weeks, whatever it was. I don't know. I mean,
she might have legitimately been afraid of that, but it doesn't make it reasonable. There's just no reason for that. And even if you disagree and feel she had a reasonable belief, it wouldn't be imminent serious physical harm.
all right, your time has expired. I see no further questions. Thank you very much.
Thank you, Your Honors.
This brings us to our final case of the day, which is number 25839. It's Madoshus versus the somewhat confusingly named Mr. Cooper, who is not a person, but apparently some bank entity. We will hear first, when everyone's ready, from Attorney Dion.
Good morning, Your Honors, and may it please the Court, Attorney Todd Dion on behalf of the appellants Armani and Kimberly Madoshus. The issues in this appeal concern damages regarding the appellee's pattern of failing to comply with federal loss mitigation regulations, as well as a ripeness issue regarding the appellee's failure to strictly comply with a condition precedent notice of default and acceleration under the terms of the mortgage. The complaint outlines a prayer of relief asking for damages based on this pattern or practice of failing to comply with the regulations, as well as an injunction enjoining the appellees from proceeding with the pending foreclosure, and also an order for Mr. Cooper to review the appellants for loss mitigation in good faith.
Okay, so before we get to patterns and practices, let's go to individual acts of noncompliance. Let's say I were to agree with you that it was not compliant to send the 2 notices that were sent to the bankruptcy attorney. That is, that's not who it was supposed to be sent to, I guess, under RESPA regulations. Is that right?
Also under paragraph 15 of the mortgage specifically says that any notices should go to the address.
Okay.
Should go or must go? Should go or must go?
Must go, yes,
Okay.
to the address, yes.
So let's say those are, we're saying they're violations of RESPA or its regulations, because that's what this cause of action is for, right?
Correct.
Violations, all right. I guess you also allege a violation in that, maybe I'm messing this up, in that you don't think they gave the real reason for the denial of the 4th modification when they finally did notify you.
Correct, yes.
And your basis for that is, you say, the fact that they said one thing orally to the lawyer and another thing in writing gives cause to an inference that maybe the one in writing isn't the real reason. You also said something about them never having shown you this policy.
Correct, yes.
You sought it in discovery, or how did you ask for it?
I did not ask for it in discovery. I guess I was speaking of that Attorney Kulik had asked for a reference to the contract, I believe, that says that there's a maximum number of loan modifications.
The contract?
Yes, there would be a servicing contract.
Okay,
between
what
the
if
servicer
what if there were just an internal policy at this bank written somewhere? We never do this, right? 3 strikes and you're out, basically.
Yes,
Right.
something, either a policy.
Okay,
or,
but you only asked for a contract, is that right?
yes.
Okay.
Well, Attorney Kulik had done that, either the
Okay,
policy.
now tell me the damages that flowed from each of these individual acts. So they never sent a notice of, I guess, completeness of your application, is that, or they did?
Correct. Well, there's one modification effort, but 2 applications. The first application was in 2020, and my client was in an open bankruptcy at that time, but the mortgage says that they should send these notices directly to my client, especially since my client
Okay, and
was...
the ones they didn't send were? The ones they sent to the bankruptcy lawyer, not to the proper person,
They
or?
sent a notice that the application was complete.
Yeah.
And then they did send it a notice citing the 3 modification maximum rule, but
Okay,
that was
so
sent to
now-
the bankruptcy attorney.
How were you damaged by either of those acts? Or your
Well,
client?
My
damaged,
client would have known right away, if he was notified directly, that he's dead. He can't get a modification,
And
period.
therefore, he would have done what that cost him more money?
He would have either sold the property, or he would have tried some other option to save the property.
Okay, but I don't understand what I mean, without you telling me what that is, I don't understand how you're going to prove damages.
I would concede that as far as individual acts, that there would be difficult to prove actual damages. But when we have this pattern of not informing my client, it took Mr. Cooper over a year and a half to finally tell him directly that he reached this 3 modification limit. And in doing that, he had to hire attorneys he had to hire Attorney Kulik to find that out. He shouldn't have to chase Mr. Cooper for the actual reason why.
But it's only the pattern and practice, you say, that caused him to have to hire this lawyer.
Correct, yes.
So if I think a pattern or practice has to be more than 2,
I think it's a lot more than the Brown case, I believe the court cited, where there was 2 letters that were not complied with. This is over the course of a year and a half where...
If I think a pattern or practice has to be more than 2 violations, if I think it's not a pattern if there's 2, I think it's 2 things. And I think a pattern sounds to me like, oh, several things.
Yes, Your Honor, I think there's more than 2 things here.
That are pattern and practice of violating RESPA. That's the pattern and practice we're looking for, right?
Correct.
All right, what's the 3rd, 4th, 5th?
Mr. Cooper contacted him during COVID, stating that there was COVID relief, that he could defer all of his payments to the back of the loan and apply for a modification. They never mentioned to him ever about this 3 maximum modification. So he applied, they sent the notices they didn't send the notices to him directly, so for whatever reason, he was left in the dark about that.
How much time elapsed between the time that he notified the bankruptcy attorney and the bankruptcy attorney? Did the bankruptcy attorney eventually notify your client, or how did he eventually learn?
My client claims that he didn't hear anything from his bankruptcy attorney, that he didn't even know about it, that he didn't know until later when he had called them and they said, well, this would have been in 2021. About a year later, he called to ask about his modification and they said, apply again.
And so the bankruptcy attorney never contacted them and told them either?
Correct, yes.
That might not have cured the RESPA violation, but there's no actual notice for a year.
Correct. So in 2021, he was told you can apply for a modification again. He was told by Mr. Cooper, again, the 3-day maximum limit wasn't mentioned. He applied again through Attorney Kulik, and first internally, according to their statement of facts, they determined that the payment, they couldn't lower the payment because of the structure of the loan. Then my client called them. He had to call them to get an answer about what's going on with my modification, and they told him you don't make enough money. Then Attorney Kulik got involved, sent them a threatening letter, and it wasn't until after the threatening letter that they respond with, you're beyond the 3-time limit. So that is the pattern of violations over the course of time. So based on that, my client had to hire Attorney Kulik and eventually myself.
So the violations are only specific to each loan modification, or you can sort of layer them over just the course of the entire interaction of the time that you have the mortgage? I mean, did the filing of the 5th modification request in October of 2021 reset the clock on violations? Does it?
Since my client didn't receive any notification directly from the previous effort, I would argue that yes, it's continuous. That he didn't hear. The regulations are designed to streamline this process and make it efficient for the sake of the customer, so they know what they're doing. My client had no idea that he was denied the modification, or that there was this limit until a year and a half later, after he initially had applied due to COVID.
But you say there is no damage from that by itself. You said that if you look at each individual violation, not telling him, sending to the wrong person, and therefore not telling him is only one violation. I understand that there might be a pattern of practice, but that violation itself, you say, didn't lead to any
Well, the
damages.
violation, there was a violation of the 30-day rule regarding the October 2021.
Okay, but no damages.
As far as damages goes, I wouldn't say that there is any damages.
Well, isn't that what the judge relies on? I think it was Judge Tobit. Doesn't he rely on the fact that you haven't shown any damages?
Yes, that's what he relied on.
Now, if there's
Now
a,
we're asking you about that.
so if there's a pattern or practice, though,
If
I
there's
don't
a-
remember what it is. There's
There's a pattern of
statutory
practice,
damages
there's
or some-
statutory damages.
and,
Yes.
and attorney's fees, obviously, for any of these, if there are damages for any violation. Or only pattern or practice gets attorney's fees.
Only pattern of practice. Only pattern of practice. And as far as the time goes, I would have to show the pattern of practice to show the time that it took my client to finally figure out that he has no chance. And during that time that he lost, the balance is growing, the attorney's fees are growing, and
But the
fees are-
balance doesn't matter because it's only the statutory amount under the practice, right, under the,
Yes, under the pattern of practice, yes.
the pattern of
I'm simply
practice.
arguing statutory damages.
okay.
it
So it's the
looks like.
2,000, or isn't it the 2,000 maximum or something?
There was a 3-time maximum. But,
A $2,000 cap on
yes,
the
oh, yes,
statutory
yes,
damage.
$2,000 cap, yes, per violation, yes. So that was the argument for damages.
Can I ask about what I'm going to call ripeness, although that's not exactly what the judge called it, this question of had some foreclosure action taken place such that you could bring your suit saying stop your foreclosure action and also damages action. The judge cited Beaton v. Land Court, a 1975 case. I would have thought that if you bring a Service Members Relief Act case, you're foreclosing. There's no other reason to bring one. But for whatever reason, I read Beaton and it says, no, that's not enough. There has to be some further act.
Yes. And I believe, I would say the further act is acceleration, or
Do you have a case that says acceleration means that they are exercising whatever it's called, the right to sale, or, you know, whatever it is you're trying to enjoin?
as far as foreclosure, you have to accelerate before you foreclose. I don't have any case off in my mind that would say that, but logically, you have to accelerate because you're foreclosing on the entire amount, not just a partial amount, so you have to accelerate the whole thing.
But you don't have to foreclose just because you've accelerated.
You don't have to foreclose if you accelerate, and there's a right to reinstate after acceleration, and it's not until the moment of acceleration that the lender is allowed to charge attorney's fees and costs, or the costs related to collection of the debt. So I think right there, there's ripeness at the point, I would argue, not just, I'm sorry, Your Honor. you
But
wanna-
to enjoin the foreclosure is the ripeness. Right, I understand maybe there's something, you know, if it's done wrongfully, then there's some, you know, now they owe you damages because they've begun collection activity and cost you some money. I get that. But I'm asking about the foreclosure, which is what your complaint talks about.
Yes, as far as foreclosure goes, acceleration means that you're going for the full balance, that you're going to foreclose, that starts the process. And I would say even when the homeowner loses the right to cure before acceleration, there's skin in the game after that date to cure the mortgage. At that point, the borrower loses something. They lose their right to cure the mortgage and avoid acceleration and avoid the additional fees. So I think the ripeness inquiry would go as far as that goes, all the way to, or as far back as the date that he loses his right to cure. When he loses the right to cure, he had the whole loan. Well, they can accelerate on a dime as well. There's no requirement of an additional notice of acceleration, which means after that cure date, they don't even have to notify the borrower. They can just say, we're accelerating the loan, we're adding all these fees, and you have to pay XYZ in order to reinstate. So as far as ripeness goes, I think ripeness occurs when the borrower loses the right to cure the mortgage, which leads to automatic acceleration, which leads to foreclosure. And
Did you quarrel with the, you said that they sent a notice saying that your client didn't make enough money. Did you say that?
they represented that to him in a phone call. And I believe I think they admitted to it in the statement of facts.
To his lawyer?
To my client.
Oh, I thought it was a call to the lawyer, but all right.
Yes, I believe it was my client. My client said, and then Attorney Kulik had called them as well, and they said no insufficient income. They never mentioned the 3-time limit rule until later. So that's where I see Mr. Cooper as committing errors. I wouldn't go so far as say they're playing games with it, but they're definitely giving erroneous information. Why not tell the borrower right away, you're at the 3-time maximum, forget about it. Instead, this leads my client to think, well, if he's self-employed after COVID, if I make more income, perhaps I can try to modify again. He didn't know that he was dead on arrival.
Your time has expired. I see no further questions. Thank you very much.
Thank you.
We will hear next from Attorney Merritt.
Good afternoon now, members of the court. So what you just heard was largely the first time in this appeal that some of the substantive issues were even addressed. But let me just back up. One of the threshold arguments I make in my brief is that, look, we have a fundamental problem here. The appendix wasn't included. Why is that relevant? That's not a nothing burger here. Is because what you heard in my brother's argument just now was a series of citations to materially relevant points of the record from the trial court and what should have been in front of this court weren't included. And based on that, my brother made, he made mistakes. I'm not going to say he was intentionally trying to deceive the court. I don't think it was that. But he was making mistakes. Why? Because he didn't include the record from below. That failure is not minimal, and throughout my argument, I'm going to highlight certain areas where that shines. And so just as a for instance, one of the questions that was asked is, I think it was Justice Rubin, well, I think you were saying there were inconsistencies and the reasons why a modification was denied in December of 2021. And it was, well, the borrower called and he was told this and then this happened. Well, what actually happened, and if my brother had included this in, in his appendix, and this was included as part of Nation Star's affidavit that was part of the joint record appendix to the trial court. What happened was on November 29, 2020.
What volume, what page?
That would be 429, Your Honor. Of my supplemental
Of
appendix.
Your supplemental,
yes,
I see.
Yes, everything I'm talking about, I thank you, is all in my supplemental appendix.
Okay, go ahead.
So, and this is just a for instance. So what happened is on November 29, 2021, by this point in time, the borrower had defaulted on his third modification. He had been previously denied back in May 2020 when he was in bankruptcy. He gets out of bankruptcy, hires Joe Kulik's office, submits another modification application in October of 2021. I'm being very quick, but that's kind of takes us to where we are. So then, November 29, 2021, Joe Kulik's office calls Mr. Cooper to get an update on what's going on with the modification. Talks to a customer service representative. And if you go down sort of midway through 11/29/21, 12/14 is the time of the call, Olivia Nolan from Kulik Law, calling for mod update. Advised was denied due to insufficient income, but will get more info of the denial. So, it's a customer service representative reciting, well, this looks like one of the reasons, but I have to get more information on the reason for the denial.
Well, it doesn't say looks like. It says that is at least one of the reasons, due to insufficient income.
But it also says...
Yes, we'll get more info of the denial. Maybe there's other reasons, or maybe it'll show the exact numbers, or we don't know what that would be. But nonetheless, why would she have said, or he have said, was denied due to insufficient income?
Let's look at that, because my brother's painting that as being inconsistency. For starters, the statutory basis that my brother is citing to under RESPA says nothing about inconsistencies. It just says you have to tell the bar, if you're going to deny them.
You have to tell the
you have
bar
to
the
tell them
reason.
in writing. And just so we're clear in the record, and again, this is another reason why the failure to include the appendix is just unforgivable here. The record clearly shows this gentleman was informed 3 times from May of 2020 until 2021 of this 3 strikes and you're out rule. And I'm being very quick when I call it that, but that's essentially what it was. So the first, so getting back to his denial in December of 2021, that's what he was told. And this is the record of my supplemental appendix, page 435, it begins. And this is sent to Mr. Madoshu's care of his attorney's office. And just so we're clear on that, because I know sending letters to attorneys is an issue here, apparently. Kulik's office had previously asked, send everything to us.
He's not arguing that
Yeah,
Kulik is not him. He's arguing that the bankruptcy, okay.
Yeah, but in this denial letter, they're clearly telling him one of the reasons is for the 3 strikes, we'll call it. This was previously told back in May of 2020 as well. And so this wasn't a new thing, and that was May 13th, 2020. Admittedly, this communication went to Mr. Madoshu's bankruptcy attorney, but he was told this 3 strikes rule back in May of 2020.
Where's that in the record, in the appendix?
That is supplemental appendix, page 268. Page 268 in the supplemental appendix. And again, this denial letter was sent in a response to what would have been a request for a 4th modification, and he was told again, I'm sorry, sir.
Yeah, but this is the one sent to the bankruptcy attorney.
It is, but just so we're clear, Your Honor, the violation here on the particular communications here, it's administrative. They're claiming, well, yes, you sent an acknowledgement letter within 5 days of receiving my application, but you didn't send it to me, you sent it to my attorney. That's a violation. And I think Your Honor's question, or there's a question about damages here, really gets to the heart of this entire RESPA claim, which I'm going to point out as well. My brother doesn't brief that issue at all in his briefing.
Well, and he's conceded that there are no damages flowing from each individual violation.
But then he doesn't also brief, but then I guess
But he says there's a pattern or practice.
First time that has ever been mentioned in this entire appeal is now today, when he's saying this is a pattern and practice, which, by the way, there's not a single case that talks about you had 2 communications based on ministerial violations. And again, in the complaint, if you look at the complaint,
Page 6 of his brief, in addition to the actual damages stated above, the appellant plaintiffs asked the lower court for statutory damages pursuant to 12 U.S.C., et cetera, for defendants' pattern or practice of noncompliance with the mortgage servicing regulations described in, but not limited to, this court and all costs of this action, including attorney's fees in connection.
but
So
that's an introductory. But does that brief a substantive issue? The issue was, did the trial court commit an error of law then in determining that 2 violations did not constitute a pattern and practice? And I guess this is.
Well, I agree. There's not argument beyond that, but it's all right.
And that's what I'm saying. This is the first time this has ever been mentioned, really, and developed in any substance here, where they're saying, well, these 2 letters are a pattern and practice. And I think one of Your Honors, and I forget, and I apologize, asked, well, what case says that? And the reality is there's no case that says that. The cases say, well, 2 instances alone do not constitute a pattern and practice. And that rule is especially pronounced here because keep in mind, and I think Justice Allen was hinting at this maybe in a different context, though, was saying, well, do the violations have to be in connection with specific loan mod apps because you had 2 different apps going on here, or can it be like a rolling theme? I'm not aware of it can be a rolling theme, and with that being said, the problem is we had, again, the violation in May of 2020 is a letter was sent, timely sent, to a bankruptcy attorney because this gentleman was represented by counsel. So that's the first violation in May of 2020. They're not complaining in their briefs or in their complaint that it was denied in May of 2020. It's just who it was sent to. That's a violation. So then fast forward to December of 2020. They're complaining, again, it's not that the loan mod was denied. That is not what they're claiming here. What they're claiming is, well, you were supposed to send this letter within 30 days of the October 21 application. You sent it roughly 60 days after. That's a violation. So we're talking about 2 ministerial acts, okay? There is not a single case I'm aware of that says, number one, 2 acts alone, regardless of ministerial substantive, create a pattern practice. But then you take it a step further and you say, well, what were the violations really here? You know, let's look at this. What are we talking about? We're talking about ministerial violations, and then
They're ministerial, but why is the 30-day rule, why does that rule exist?
It exists so that way they can know on a timely basis, because if you look at it, you know, the supposition of a lot of these rules, and again, this section of these regulations, it's called loss mitigation procedure, this is interwoven throughout the regs. The regs are sort of presuming, well, if someone's in default, they're probably on some sort of a foreclosure track as well. And one of the reasons why they want the 30 or 5 days acknowledgement, for instance, 30 days once the full package is received, is because this has to happen quickly. You know, one of the ills of the mortgage industry from years ago is that folks would send in these packages and it would just essentially go into a dark hole and no one would hear anything.
Right. So it's ministerial to the lender, perhaps, but not to the mortgage.
But keep in mind, they are, okay, but then it gets to, and I think it was Justice Rubin's question was, okay, so these things happen, and I think Justice, Your Honor, mentioned as well. So these things happen. The trial court basically presumed there were violations. The trial court made that presumption, skipped right to damages. And at that point, what is my brother alleging as his damages here? He's alleging, well, I had default fees. I had to go hire an attorney, arrearage fees. Well, hold up a second, because Mr. Madoshus got a loan law, the third one, in August of 2018, defaulted on that in February of 2019, and then that sent into motion all of these alleged damages that he's now complaining of in this case. And that's why the trial court, rightfully, by the way, said that's not the but-for. You know, that doesn't satisfy a but-for, approximate cost, however you want to describe it. Those losses don't stem from a letter being sent to your attorney instead of you. Those losses don't stem from, a denial letter going out within 60 days as opposed to 30 days. Those are directly associated with your prior default on the modification. Again, the reason why the court was so quick, the trial court was on the pattern and practice damages, is because there was no allegations at the trial court level of pattern and practice. It was never subsequently briefed. The only briefing to the trial court, and before this court, by the way, was just going on and on about why these are violations, why these are violations. We're past that, okay? I think everyone is saying, okay, there were some technical violations here. What's the fallout? And that's what my brother has never analyzed up until today.
All right, so let's talk about pattern and practice, because that's what he says today.
Yep.
So maybe I can agree with you that 2 things aren't a pattern or practice. He says there are other things, and one example, I guess, is maybe, but this is a question of fact, I think, maybe the real reason wasn't given. Maybe it isn't really a 3 strikes rule.
But this was consistently said.
Except for the 1 phone call.
And I think it's crucially important to remember the basis of liability that my brother's going on. And I'll admit, this is a bit of a technicality, I'll admit that point, but he's basically saying, he's citing to a provision in RESPA that says you have to give notice in writing of the denial. And then he's saying,
the reason for the denial.
Yes, the reason for the denial, and that was the 3 strikes rule. This reasoning, Your Honor, was told to the borrower either directly or to counsel. And you can say, well, sending a letter to an attorney, not a borrower, is a violation.
That's not what I'm saying. I'm saying that the phone call may raise a genuine issue of fact.
But what's it relevant to?
Whether there's a 3rd violation of pattern or practice.
But again, this has never been pledged, so and this is what I'm saying is, what is it relevant to? What statutory provision does that violate?
I thought a pattern or practice had statutory damages.
But it has to be a pattern in practice that's based upon a violation. And you're saying this one, and this is a hypothetical, I believe.
Yeah.
But you're saying, well, this is a violation. And I'm saying, well, respectfully, it's not. It has to be tied to some regulation that's a violation of.
Well, you have to give the reason. And if you give a false reason, I think it's reasonable to say that's not.
He called, okay. So he called, his attorney called.
I'm not saying, by the way, that you did this. I'm just saying, does it raise a genuine issue of fact?
It does not, because it's not relevant to any of the claims pled. Again, he has raised this argument really for the first time today. His claim as pled is alleging the violation is not this phone call. The violation is you denied him outside of the 30 days. And I think to further answer Your Honor's question, and believe me, I am trying my best to do it, we haven't even touched upon really the threshold, one of the threshold inquiries onto the substantive analysis, which is, can they even call foul on any of the stuff that happened here from basically May of 2020 to, we'll call it December of 2021? And if you look at the RESPA violations, and this was the first argument before the trial court down below, and it's raised in my brief as well, is I believe it's 1024.41I, and essentially what that regulation says is a servicer only has to comply with this thing one time.
Well, you left out the part of the regulation that says if the borrower has been delinquent at all times since submitting the prior complete application.
But as
and I may be wrong about this, but I thought that there was a period of time when, because of the modification, the borrower was called current.
yeah, after the, and I see where Your Honor's getting to, okay? So, and I can address that question, because even in some of the opinions nationally, there's been a little bit of issue on that. The decisions I cite to basically say, look, a servicer, so here Mr. Cooper only has to go through this process once. Mr. Cooper modified this guy twice prior to getting into the stuff we're talking about here. But to answer Your Honor's question, even if that's the case, so they go through the whole review process in May of 2020, he's still in default, and then they're crying foul over stuff that happened in October.
In default is not the same as being delinquent. I don't know.
Respectfully, what's the distinction?
Well, if you tell him he's now current because he has to pay all this back stuff at the end, we're adding it as a balloon, then he's not delinquent, he's current.
Just to fill in that factual gap, Your Honor, okay, I get where you're going. To fill in that factual gap, so he defaults in February of 2019, to get to Your Honor's question. He was in fact informed, he was, if we want to use the term delinquent, he was in fact informed of that. He was sent a 35A notice of default letter. I have it in here, and I do apologize, but I believe it was April of 2019, I want to say it was. He was informed of this, and then he filed bankruptcy soon thereafter that. So he was informed that he was delinquent. So if that is the relevant fact to kind of to bridge that gap, it's right there.
All right, your time, though, has expired. I see we have your other arguments, of course, in your brief. I see no further questions, so thank you very much.
Thank you very much. Thank you for your time.
And with that, I'd like to thank the court officer and the court staff for their typically excellent work. We stand in recess.